Hello, beautiful humans. Good afternoon. It is Friday, May 9th, and today we have a lot to go over. I have been out of the scene for a while, and I've been watching everything that has been coming forward, just not ready to report on it quite yet. And now here we are. I know that Trina Kay filed a 609 motion to bring in Lori's prior convictions if she decides to testify in the Brandon Boudreaux trial. So I'm aware that that's on the table, but today we're going to spend most of our time discussing Lori's motion for a new trial and the state's response to that motion. And as is often the case, whenever I'm behind the 8 ball and I don't have my documents together, I call my friend Joe Schmo, and he offered to come on today to help me out with this. And so here he is, everybody, from the Joe Schmo 88 channel. Joe Schmo.
Hi, everybody.
Good to see you.
Good to see you too, Megan.
Thanks for helping me out with this today. I appreciate it. I've been out with one daughter getting married and another daughter having a baby. And so I'm back in town, finally, back in my own studio. I had good intentions of doing some reporting while I was visiting my daughter. And then the baby had to go back to the hospital. And so I had to pivot a little bit. Baby's doing better. Baby's home. We're waiting on some test results, but mainly just a little extra jaundice for my little newborn prince.
Oh, well, we'll definitely be sending out prayers for that, for answers, first of all, and then a good diagnosis and treatment if one is needed.
Yeah, I appreciate that. Thank you. It's always scary when it's a little guy. You don't really, it's hard to tell what's wrong because the symptoms aren't immediately evident all the time. So,
right.
Anyway, I never feel like I get enough time with my oldest daughter, and I've got a 5-year-old grandson, and now the newest one is just a couple of weeks old. So it was fun to spend some time with them, but I hope to get back there soon. I miss them already.
Nice. Yes.
So you are still down in the Phoenix, Arizona area, is that right?
That's correct. Yeah. And that's why this funky camera view, and I still haven't figured my studio out. I have a new camera coming though, and I'm hoping the new camera helps, but I've got the virtual background up yet. I'm not actually outside the steps of the South Tower at Maricopa Superior Court, but I'm trying the virtual background as opposed to the, right? They should.
Spent a lot of time there. Yeah. So I know what it's like when you're traveling and having to figure out cameras and lighting and all of that kind of stuff. So are you planning to stay all the way through Brandon Boudreaux's trial?
That is currently the plan. Yes.
Yeah. All right. Well, best of luck to you with that one. I'm not going to be coming to this trial in person, except to see the verdict and the sentencing. I think I'm going to stay in my comfy little home studio and report from here.
Yeah. If Judge Boreski holds this in his original courtroom, it's going to be a circus because it is so much smaller and the seating is so much more limited. Like it's going to be crazy.
Yeah, I think there's something like 20 seats in that original courtroom. And so I don't know how they're going to handle that.
Yeah, there's 30. And so the media is probably going to get 10 of those. The family's probably going to get 10 of those, which leaves like 10 for the public. That would be crazy.
Yeah. So are you officially considered media, or are you going as a spectator?
I actually have somebody reaching out to me to maybe be media on this one.
Great. That's awesome. Good for you. I noticed that you and Kresha did a couple of videos on her channel as well. So I'm glad to see you collaborating with lots of people. That's awesome.
Yes. Yeah. Kresha and I have a series going on ritual abuse in the Mormon Church. I think we did episode 6 this last Tuesday. So that's been going well. Yes. And we've been doing she's been taking us down some rabbit holes.
Yeah, I'm going to have to catch up on that. She and I have had several conversations about it, and it's one of those things that is such a deep well that I really don't feel like I have the bandwidth for it. So I'm really glad that she's covering it, and I'm looking forward to catching up with everything you guys have been talking about because I think it's important.
It is.
Well, should we dig into these motions here?
Oh, we have to increase our bandwidth just a little bit for these.
Yeah, exactly. So I'm just I want to briefly cover this one motion here that the state entered about the witness list. And this is basically an order from the court directing Lori to file an updated list of witnesses specific to the Brandon Boudreaux case, because her original witness list was supposed to be, from what I understand, both cases. However, she could not present a compelling reason to the court why any of those witnesses should appear. She couldn't talk about what their contribution would be to what evidence they could offer. And so she did not, and then she ultimately didn't end up calling any witnesses. And so I think the state is saying here that there's some confusion as to, is she going to actually call witnesses? And if so, whom? And so they just need an updated list. Is there anything else worth mentioning about this particular filing?
Well, like you said, she didn't actually call any witnesses in the first trial, even though her original defense witness list included those, like 15 people, and Nate Eaton got kicked off the list. And then Brandon
Right.
came into trial that first day.
Right.
And the judge, he had filed a motion to appear, or the state filed a motion on his behalf. I don't remember how it went, but the Judge Bresky said, "Does the defense have any objection to that?" And Lori said, "Yes, I object to it." And judge says, "Well, what's his relevance?" And she couldn't really answer to his relevance. And she was always like, "Well, if I tell you his relevance, then that's going to give my whole defense case away." And I'm like,
Right.
okay. So judge, I think, so Brandon left the courtroom for a little bit, and the judge left the courtroom for a little bit. And I think the judge called Brandon in there and just had a little chat and said, "Do you think you have any relevance to this case?" And Brandon's like, "I don't know what it would be." So judge overruled her objection and allowed Brandon to come back in.
Yeah,
And
so I was actually sitting right next to Brandon that first day in the courthouse. And so I don't know if it was it the judge that spoke to him, or was it the prosecutor? I was under the impression that it was Trina Kay that called him back to question him, because that's her right
it may
as
have
the
been, but
prosecutor anyway.
yes. Yeah, it may have been, but the judge left at the same time. So I was a little confused as to what was going on. But all I
Right.
know is Brandon got allowed back in, and the judge said he's off of the defense witness list, but with prejudice, which means she could have put him back on the witness list at some point if she had
Right.
been able to prove some type of relevance to the 2021 case.
Right. So without prejudice just means that in the future, if she wanted to call him for this case, she could have. But I think the difficulty was that Lori was under the impression that Brandon had been texting with Charles in the days leading up to his death as well. And Brandon basically told the prosecutor, I wasn't in contact with Charles because he'd been blocked as a contact on my phone. And so he said, I didn't have anything relevant. And so what's interesting is that if there had been communication between Brandon and Charles, certainly the state would have wanted to bring that in. They would have included that in their discovery, and Lori would have been aware of it. But since she didn't see it in discovery, she was just going off of her own impression or her own idea that she believed Brandon and Charles were talking. And again, I think it was another effort on her part to find out what people were saying about her. And so, I don't think,
which is why she was obsessed with getting Charles's phone from the Chandler PD. She was
right.
obsessed with that.
Yeah, definitely. So Brandon didn't have any relevant information to offer, so he wasn't called. And then the rest of Lori's witnesses there was Detective Coons was on there, but he was already on as a witness for the prosecution. And then it was Lori's dad, Barry, Lori's mom, Janice, Summer Shiflett, Lori's sister, which her name was misspelled on the witness list, which you would have thought they would have gotten that right. And then I believe Zach Cox, who is Adam's son. I believe Adam Cox was on there, but he was already on for the prosecution as well. And I can't remember if there was anyone else relevant, but it was basically family members. Oh, there were friends of Tylee's that were on the list as
Yes,
well.
two of Tylee's friends were on there. Yes.
Right. And then Lori's former bishop was on the list as well.
Right.
And there again, what relevance would he have? Well, I thought it was pretty hilarious when Lori did not want to give away her legal strategy, because she has to disclose all of her evidence to the state anyway. She has to disclose all of her witnesses. The state's allowed to interview all of the witnesses. So they're going to know basically what information they have to offer, and they can pretty well formulate what her strategy is going to be or what she's going to argue. I think she felt put on the spot in front of the public and in front of the camera in the courtroom and didn't want to reveal it to the rest of us.
Right. And in the end, the only one that she was able to subpoena and the state was able to interview in a timely fashion was Zach. That was it. That was the only one on her list that they were able to interview.
That's right. And I remember them talking about their interview with Zach, or actually it was Lori's investigator that talked about their interview with Zach, and that he was very hostile towards the investigator and that he disagreed with some of the things that his dad, Adam, said. And so, there was no real material evidence that he could have offered. And so, they didn't allow him. Yes, the landlord was on the list. And then the other thing that was interesting and terrible is that Lori used the discovery that she found on Charles's phone to get contact information for family members. And she subpoenaed, I believe it was Bobby Vallow, Charles's brother, as well as Larry Woodcock. Yes. And there's no way that she should have had access to that information, first of all. And she's precluded from subpoenaing family members of the victim. And she claimed in court, the first time that it happened for Bobby Vallow, she claimed that it was an oversight and that there was some confusion with the jailhouse phone call, and she got cut off every 20 minutes. So there was a misunderstanding. Well, then the very next day, they found out she had subpoenaed Larry Woodcock. And then at that point, she claimed, I just signed a stack of subpoenas and I didn't know who they were going to. Well, that's BS, because we know that she saw that. She saw who she was subpoenaing. And I'm sure that she did that on purpose.
I'm so sorry.
Exactly. Yeah. So that's, it's one of those classic manipulator things where they're going to try to play it off as a mistake when it was absolutely intentional.
Yeah.
So anyway, that's enough of the witness list. The state is requesting a revised witness list. Now there's going to be a final trial management conference, I believe, on May 14th. And that's the deadline that she has to produce the witness list by that time, if I'm correct.
That sounds right to me. Yes.
Okay. So now we will take a look at, that's the minute entry again. We will take a look at, want to take a look first at Lori's motion for a new trial. Now, this is the first time that I'm actually reading through this. I scanned through it when it first came out. So I know basically what she's trying to assert in here. I don't think that anyone is necessarily shocked that this is the tack that Lori is trying to take, because she's made some of these claims before, prosecutorial misconduct and discovery violations and all of that. Now she's using these same arguments to try to get a new trial, but with the twist that there was juror misconduct. And I think you and I, Joe, had a little conversation about this when it first happened.
Yeah.
You sent me a clip so you had clipped out the part of the juror's interview and you posted it on X. Is that the first time that came out?
I did on YouTube and X. So after that day, after that verdict day, when it was all madness, after the verdict was read and the jurors were let out, and you'll see in Trina K's response, she says they were mobbed by the media, which is probably a pretty fair assessment. They were. I couldn't do that. I couldn't participate in that. Like, I got to figure out, me as a media person, like, I got to go with my conscience, and I couldn't go running after the jurors and like stick a camera in their face.
Yeah,
but
that's understandable.
But yes, so I was watching the juror interview with Fox 10, and in my post verdict reaction video with Trial TV Live. That was the first time I had seen it, and he said, "What? What did he just say? I need to hear that again. I got to hear that again." So I listened to it again. I clipped out just that part, and I added captions to it so it's easier to see what he said. So then Courtroom Confidential used it, then Nate Eaton used it, and then Colby used Nate's copy of using my video. So it was on 3 different channels like pretty quickly. And Colby gave his reaction to it too. And then Trina had her own reaction to it. But yeah.
Yeah. And we're going to watch that. We are going to play it here in just a second. I just want to say, yeah, you definitely can hear Justin Lum say, "What did he say?"
Yes.
So I want to give people a little bit of a layout of how this worked. The doors behind Joe are the doors into which the jury would go every morning. That's the lineup right there outside of the trial. And the security is right past those doors. And so the jury would have come right out here. And the reason we have this view is because right across from those steps is a little tent where the media would camp out. And there was at least one camera there every single day. I know that Law and Crime and Court TV, a couple of them were doing interviews outside the courthouse every day at lunch and afterwards. And then if you go down the steps and you go toward the street, which is actually that way in Joe's picture.
No, wrong way.
Yeah, that way in Joe's picture. There's a crosswalk there to get into the parking garage. And I can tell you from experience, when you press that crosswalk button, you could be waiting for a good 5 minutes before you get the okay to cross. In addition, the jurors were waiting for the shuttle bus, which was taking them to their parking area at the end of the day. So there's really no escape. And the first day that Colby attended court, he went out to this media area to do a quick interview with Nate Eaton. It was prearranged. And I was with Laura Ferris, who's one of Kay Woodcock's friends, and we were waiting to cross for the garage. And then suddenly we heard footsteps running towards us. And one of the reporters from one of the channels and her producer had heard that Colby was giving an interview, and they were making a beeline to go that way. And so I can just tell you, it definitely is a situation where media knew who was coming out of the courtroom when. They were being advised by producers and other people. And so they knew that the jury was going to come out. And I'm sure a lot of them, I had the curiosity too. A lot of them wanted to get that first reaction of what it was like when they found out about Lori's other convictions, because that's what we were all curious about the entire time. They had no idea that she had already been convicted of killing her children and Tammy Daybell. And we were all curious to know what the jurors would think when that happened. So I was not surprised that the media tried to get as many of them as they could. And sure enough, at least 3 of the jurors that day gave interviews. Now, this is juror 15, and he's already somewhat infamous to me, and I think to you as well, because there were 2 separate instances where he was isolated in the courtroom by the judge to answer for his behavior. And
3.
Was it 3? Okay. The first time, if I remember correctly, he had been texting during testimony.
Well, before that, he's the one that left his phone on that wooden wall in front of them. And his phone went off during that. And we were all weirded out by that weird sound that was going on for like 20 seconds. And everybody in court's going, "What is that? Are we being portaled out of here?" And they come to find out, they investigated, and he put his phone up there and his phone was on. And that was the cause of that. So that was episode 1. And now episode 2.
Right. So there's a little wall right in front of where the jurors sit. And there's the basket where they can put their questions. And I believe there's a microphone there as well in case they need to speak. And he had set his phone down right next to the microphone, and it started ringing. And I could tell by the rhythm of the buzzing that it was a phone ringing. And I was figuring that a microphone was picking it up somewhere, but I didn't catch that it was on the juror wall. But we all heard it in the courtroom. Trina K even stopped her questioning because everybody was trying to figure out what this noise was. And then
Judge Bareski was looking around. His assistant was looking around.
Right. It went to voicemail finally. But here's my thing. If I put my phone down and I hear that buzzing, that rhythmic buzzing, that means that there's a phone ringing, I'm going to be thinking immediately that it's me.
Mhm.
You know, this juror was completely oblivious to the fact that it was his phone making that noise, because he didn't even make a move to try and pick it back up. So yes, they did call him out and say, you know, you need to have your phone on silent or whatever it is. Then incident 2, I guess he was texting during testimony one of the
During
days.
Captain Keller's testimony. And then at the end of Captain Keller's testimony, judge said, are there any juror questions? And there were 4 very detailed, specific medical questions that were asked after Captain Keller's testimony.
Right. And I was curious to know, who was it on the jury that had some kind of medical experience? We'll come to find out it was juror 15. But they were asking him whether or not he looked something up on his phone because of that specific medical question that came across. And he said that no, that he was texting with his daughter. And then the judge directed him to make sure that his phone was turned off and put away during proceedings, because that's highly irregular.
Isn't it highly irregular that they even allow the jurors to take their phones into the jury box with them?
It is. Yes, it is to me for sure. I thought that the jurors had to turn their phones over and couldn't take them into the courtroom with them. If I were a judge, I think I probably would want that to be the case.
Mm-hmm. Yeah. It's common sense, right?
Yeah, I think so, definitely. Now, the final time that Carl, we know his name is Carl now, juror 15, was reprimanded, shall we say. He was asked to stay behind, and someone from the court staff had brought it to the judge's attention that 2 of the jurors were talking about the case, which they're not supposed to do. They're given that admonition every single day. Don't talk about the case and don't look up anything about the case. And then he was isolated by the judge, and the judge said, it's come to my attention that you were talking about the case. Did you make a comment to another juror about the Social Security testimony? So this was right after the Social Security agent had testified about Lori's appointment and the amounts of money that she would be receiving as a payout, as the death benefit. And Carl, juror 15, made a comment to juror 16, who was sitting right next to him, on the way out, I guess, or back in the hallway, about, that seems like a large amount. Like, that seems high.
I think it was the other way around. I think juror 16 said to juror 15, that's a lot of money. So juror 16 said to Carl, that's a lot of money. And Carl has his own experience with Social Security Administration and him applying for some type of benefits. So Carl responded to him, yeah, I have my own thing going on. And there was a little bit of, discussion there that was inappropriate.
Yeah. So there were 2 or 3 sentences of discussion where Carl said, yeah, I'm fighting a battle with the administration right now over a couple of things, and it's taking longer than forever. And I think he mentioned, I have an appointment that's supposed to be during these proceedings. I'm wondering what I should do. And I guess that was kind of the end of it. So when the judge questioned juror 15, Carl, he was forthcoming about the conversation that he had, and he did admit that they had that conversation. The judge said, you're not to discuss the case. Do not talk about it anymore. And also, don't tell the other jurors what this was about. Then he dismissed Carl, juror 15. Then juror 16 came in, and the judge asked him, did you have a conversation with another juror about the Social Security payments? And there was you could hear a pin drop in the courtroom. We were all completely silent because all of us were like, please don't lie, please don't lie, please don't lie. We really did not want anybody to get anybody else to get kicked off the jury, to get removed, because we were already down to only 2 alternates. And there was a very long pause, but juror 16 was honest about it. He was the one who had come forward earlier and said that he saw something related to the case earlier. He had seen some video, but he didn't know what it was related to. He just remembered seeing it when he saw it in the courtroom. He said he didn't know what case it was for. It wasn't a big deal. The judge allowed him to stay. So he was honest also about the conversation that he and juror 15 had. So thank goodness, neither one of them got kicked off. But, when you made the comments that you did about Juror 15, that he was causing all these problems, I was like, you're right. I guess if I was the judge and it was like the third time I was having to talk to a juror separately, I might have been tempted to remove him. But I understand not wanting to take somebody out when you only have two alternates.
And you don't even know about my fourth encounter with Carl, juror number 15.
No. Oh no.
Yes.
Do you want to talk about it?
I can. I have before. It's
okay.
So it's on a lunch break, and the jury kind of intermingles a little bit with the public on lunch break, right?
Yeah.
So I'm up on a business call on lunch break, hanging around the elevators, and juror 15 walks past me, and coincidentally his phone goes off. I'm like, oh, what a coincidence. Juror 15's phone is going off again right in front of me. Not a big deal, but he goes past me towards where the public seating area is, where the media seating area is. And he parks right there on the corner between the elevators and the men's room, within like 10 to 15 feet of where the public is hanging out during that break.
Wow.
And I walked past him and I went over to where the public is sitting down. And of course, it's a bunch of people who are talking about the case. They're on a break. They're talking about the witnesses. They're talking about the facts of the case. And I go, hey guys, and I've talked to the group of public before, so they all stopped to listen to me. And I said, hey, we've got a juror hanging out right there. We should probably just like watch what we're saying or how loud we're saying it, while he's hanging out right there. So eventually, 3-4 minutes went by and he leaves, and then we can start talking about the case again. But I was just like, that's a weird place to park yourself, right there at the corner of the elevators in the men's room.
Yeah, that's definitely problematic. And I got nervous several times because, right there where the picture is, that's where a lot of us podcasters, media people would hang out and do recaps at lunchtime. And the jurors from all the cases were welcome to just wander and have lunch wherever they wanted to. And there was one day I sort of chose a place that was farther down that way in your picture, closer to where the office of the attorney's office was, the prosecuting attorney's office. And one day I was getting ready to go live at lunchtime, and I looked behind me, and sitting about 50 feet away was juror 16. And the reason I recognized him is because in the morning he was wearing this bright orange hoodie. And so he was sitting there and I recognized him and I was like, I better move. And so I went ahead and moved very far away because I didn't want there to be any problem. I knew that he was going to have to walk past me to get back to the courtroom, and I didn't want him to hear anything that I was talking about. So I made sure to move away. Now there are other journalists there that may not have been as ethical and would have been happy to talk in front of the jurors, and they maybe not realize it until it's too late. So it's just with a high profile case where you're already going to have a hard time choosing a jury, I wish that they would have been a little bit more careful about keeping the jury away from where the media and the public were. And I know that in Lori's first trial, Tom Evans said that they ate lunch together in the jury room every day. They didn't go wandering around, Yeah,
I talked so Vince is the public information officer for the entire court. And I had several conversations with him, and towards one of the last days, it might have been verdict day, I asked him, do you guys bring in lunch for the jurors, especially like while they're deliberating? Wouldn't you want to bring in lunch to the jurors, to the jury? And he said, nope, they're on their own for lunch. They're completely on their own for lunch. Wow. He said the only day of the year that juries get lunch provided to them is Jury Appreciation Day on May 1st of every year.
Wow.
That is the only time of the year that they provide it. Yeah.
Dang. That seems pretty crazy to me. So anyway, juror 15, lots of different questionable things that happened. So let's go ahead and watch now that interview with the subtitles so that you guys can see and hear exactly what all of the hullabaloo is about. Let's see, I need to remove this and then I can add this. Here we go.
Yeah. Do you remember your reaction learning that she has been convicted in killing her 2 children?
You know, I feel sorry for her. You know, I mean, driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell. You know, I mean, you got to feel sorry for her, even though, I mean, that's awful thing to do. I mean, there's something wrong up here, but what do you say? Still, you know, you just feel awful about it.
I'm driving home
So-
yesterday.
Oh, sorry. Hang
Hi,
on.
Nate.
Hang on.
Hi,
Hang on.
Nate.
Okay. Sorry about that.
I recognize that face.
Yeah, it was. I think that was on autoplay there on my YouTube.
When he said, I'm driving home yesterday, which is why I put it in red and underlined, and she's serving the next 3 lives in prison in a cell. I'm like, wait, how did you know about it yesterday, dude?
Yeah. So that was the day that the trial concluded. The jury went back to the deliberation room. They did not take a vote, from what I understand.
They deliberated for 17 minutes, which means they didn't deliberate. They may have elected a jury foreman, maybe, but they did no deliberations. Yeah.
If I remember correctly, they didn't select a foreman until after they reached a verdict. I think that's what I heard one of the other jurors say. I could be wrong about that. It's neither here nor there. Basically, that time back in the jury room was just them saying, like, we just want to go home and, you know, sleep on it. I actually did hear another account of the timing of that. And so I may be wrong about this. And I forgive me, I don't remember the names of the 3 jurors who did interview, but there were the 2 women and then Carl, I believe. And so one of the women said that they did take a vote right then and there. And there were 2 people who were thinking not guilty. So they decided, rather than get into it, they wanted to come back fresh in the morning to review all of the evidence before they started deliberating. So anyway, whether or not they took a vote right then and there, they decided to go ahead and leave for the day and then come back and deliberate. So what Carl is referencing, this is the day of the verdict, the next day. So what he's referencing is that first day when trial was over, they were still under an admonition not to talk about the case, not to Google anything. And then, you know, he makes this comment that yesterday I was driving home and I thought she's serving 3 life sentences.
And I felt sorry for her.
I felt sorry for her. Yes, exactly. And he was the one of the 2 holdouts that believed she was not guilty right up until closing statements were made. So,
he was the last holdout. The other female juror. So the one female juror was interviewed by herself, but Carl and the other female juror were initially trapped by that mob of media together. And
Tosh is the one that interviewed by herself. Yeah. Thank you.
Yes. And then the other lady and Carl were interviewed partially together and partially apart. But when they were together, she said, you know, we had a couple of holdouts and then there was a last holdout. And she looked over at Carl and he's like, yep, I was the last holdout. I admit it.
Yeah. So
my thought, so my thought immediately, well, not immediately after that, my immediate thought was, what did I just hear? But then logically you process it and you're like, one of 3 things happened. Either 1, he misspoke and maybe he wasn't driving home yesterday knowing about her 3 lives. And we're going to find out that Trina K is pushing that theory. Or 2, he knew about it ahead of time before the trial, which means he was not honest on his juror questionnaire. Or 3, he did find out about it during deliberations and he did not follow the judge's admonition to not look anything up.
Right.
So one of those 3 has to be the truth.
Right. So he did go on Hidden True Crime. He had an interview with Lauren Matias. I don't know if you saw that one or not, Joe, but
I did. Yes.
He did clarify for her that he just sort of, the days were running together. He didn't know what he was saying. He was kind of ambushed afterwards. And he really misspoke and that he did not know anything about it. He said he didn't Google it until after the verdict. The judge came back to thank the jurors, and he said he Googled it right then and there, and then left the building, and then gave this interview.
Okay.
So
I'll take him at his word. But if I'm the judge, if I'm the judge, I'm calling him before me, and I want you to put it on the record, like clarify for me on the record that that's what you're doing. Like when he says, I was texting my daughter, she just woke up in the jury box right after I just submitted 4 very specific medical questions. If I'm the judge, I want to see your phone right then and there. Judge Boreski did not. He took him at his word.
Yeah, he did. So I do want to pull up, and I should have had this. I should have had this ready to go, but I do want to pull up that hidden true crime interview because I do think it's important for people to see. I don't want to inject my opinion without showing what he actually said.
And actually, Trina's motion response to Lori's motion actually cites this interview in her motion. Yes,
it does. Yeah. So let's see. I am almost there. I thought it would just be like the first one that came up here, but I had to scroll a little bit. So I know that they've got, do they have a reference to the
to the timestamps?
To the timestamps, yeah, that's what I was going to ask. In the motion or in Trina's response?
I'm looking. I was past that when I was reviewing it. Memorandum of Facts and Authority. During the interview from 1530 to 1540, or 1210.
1206 to 1210. Juror 15 states everyone was respectful of not telling him anything about the case when the trial was going. If anyone would have, I would have put up a hand. So yeah, let's go ahead and look at these
like 12 minutes in.
Yeah. So 1206 to 1210. So let's look at that one first.
I just let it keep playing after that because there's some more around 13 and a half minutes.
Yeah. Okay, so let me add it.
Don't get copyright struck by Lauren, though. I've had that happen.
You, what was going on.
And if anybody would have, I would have, put up a hand and said, wait, don't.
Yeah. So the verdict's read. It's guilty. All of you walk out. And at what point do you say, I need to learn more about Lori Vallow Daybell?
Right away. As soon as he gave, I can't remember what he called it. It was some 50-cent word he used, of course, but
he probably just said, I release you from the admonition. That's what I'm guessing.
He did in court, actually, on that day.
Us from not being able to talk to, we could talk
before they left the court. He said, you're hereby released from your admonition.
This is the judge?
Okay. Yes. Yeah. So I did it right away. I'm still in the jury room looking at my phone, watching, or reading the story about this.
So you're in the jury room because everybody walked out sort of understanding that there were other murders, and you were one of those. Is that right? It was right after the verdict was read. You're saying you're looking at your phone.
Well, yes, that's why they told us. The judge said, "Don't be careful what you say because there's still another trial coming, and we don't want to put this one in any kind of jeopardy. So be careful who you talk to and what you say." So I understood that, but at the same time, I wanted to read up on, what happened. I didn't know anything about Idaho or Hawaii, or I knew nothing about, well, a little bit about Hawaii because that was in our trial, but I wanted to know about it.
Okay, so now I'm going to skip forward to the next time because Lauren goes back and she wants to re-clarify. And so this is at 15:30. And this is the part that Trina K quotes in her response.
Okay, and I just want to clarify too that I was just joking about the copyright strike. I did get a copyright strike, but it was her team that did it on an interview related to the Delphi case. And when we met here in this case, she apologized for it profusely.
Yeah,
and we hugged, and all is forgiven. And she said, if you ever want to use my material, just ask me first. And I did. And she let me use her interview of the other lady juror. And no copyright problems at all. She said, if you ever want to use my stuff, just let me know ahead of time. And I did.
Yeah.
So
was it a strike that you got, or did they just demonetize your video?
No. It was a strike. It was a full-fledged copyright strike.
Wow.
Like one of three. If I get two more, then they're gonna shut off my account.
So on a completely unrelated matter, I'm just gonna text someone real quick. Hey, can I use your interview video on my live right now? With the emoji that I send most frequently is this one. Sorry about that.
Tell her Joe Schmo sends his regards.
Yeah.
Completely unrelated. I know this was about something completely unrelated.
Totally unrelated. I'm so sorry. Sometimes it happens. P.S. Joe Schmo says hi. Well. Okay.
All right.
Back to yeah. So and also, yeah, I just want to say too, I'm not passing any judgment over Carl right now. I just am saying this is what happened. Some of it seems a little off to me. If I was the judge, I would call him in and question him. If he's saying he didn't see it, I'm going to take him at his word too. But according to the legal process, I think it would be wise for the judge to call him in and question him. I think that's probably going to happen just because it's all been referenced in all of these very public interviews. I think it probably needs to happen for legal purposes.
Yeah.
Okay.
As much as we feel about Lori and we know what should happen to her and what she deserves, all defendants deserve fairness in the court system and the justice system and with juries and jurors. So
yeah,
that's why it boggles my mind that they don't treat juries more exclusively, like separate them, bring them lunch, especially in high profile cases or in cases where it's a matter of 25 years to life.
Yeah. I agree with you. I'm just laughing a little bit because Lauren's producer Grayson texted me back. She says, hi, Lauren's recording something. It's Grayson. I was on her phone scheduling an appointment and I saw your message slide across the top with a sideways laughing emoji. So yeah, I think we're good to go.
Yeah, I think you're good.
Okay. All right. So with that, we will go ahead and proceed with playing this clip. Let's see. There we go.
Yeah. And so it's the day of the verdict, you learn. So is that what you quickly Googled on your phone and you saw before you walked out of the courthouse?
Yeah.
There were other murders. Okay. So you learned right then.
Mm-hmm.
And you walk out, you're trying to process what you just learned after you've left the courthouse. And then what do you do? How do you process that? Did you call somebody? Did you start watching something? What did you do next?
Well, I did. I've got 2 books about her that I haven't started reading yet, but I watched some. I watched what is that? The Sins of My Mother.
When did he get his 2 books
the
about
Netflix
her?
documentary.
Yes,
Yep.
yes.
My husband's in that one. My
I saw him.
husband.
Okay, what was your question, Joe?
He said, I got 2 books about her, like just between the end of the trial and this interview, he's already bought 2 books on it. Wow.
Yeah. And they're a lot of them are available on Kindle, Amazon, electronically. Yeah, definitely. I think if I had been serving on the jury, I definitely would have wanted to know everything about the case afterwards too. It's so complicated.
Yeah.
Let's just finish this out here.
Okay.
That's awesome.
Yeah, okay.
But I watched that, and it's hard to process. I mean, it's hard to sleep after that. It took me a
So
couple.
you had a hard time sleeping.
Yeah, or staying asleep.
Or staying asleep.
It's almost like an addiction, when you go through something this bizarre and this, I don't know, phenomenal, I guess. Taking into consideration everything that happened with rating people with, light numbers and dark numbers, and just that whole entire process of where her mind was just sinking straight to the depths of hell, as far as I'm concerned. It's hard to process all that.
Yeah. Join the club. I've been processing it for nearly 6 years.
What does your husband say?
A lot.
Yeah.
Okay, I'm just going to skip ahead now because there's another point that gets emphasized where Lauren re-clarifies. And, I wouldn't be surprised. Lauren is a professional journalist. I wouldn't be surprised if she made certain to re-clarify several times because she knew this might be an issue. So let's look at 1856 is where he talks about sort of being mobbed by the jurors.
I wanted out
or the media, sorry.
there. I mean, I was walking away and I heard this like real fast pitter patter, and I turned around and looked, and it was some little short guy running full blast at me.
I know who that is.
And he asked me if he could ask me a couple of questions. I said, okay. And then the next thing I knew, there's like 15 people surrounding me with mics in my face, So that wasn't my actual intention. I just wanted to get on the shuttle and leave.
Okay. And so all of a sudden you were sort of faced with all of us sort of surrounding you.
Yeah.
With phones.
Oops.
Yeah.
Ad break, which means we're going to skip ahead. There's one more spot, I think, and this I think is the last spot at 23:11.
You don't know how you knew that there might have been another sentencing. Everything's a blur. I do understand that. Sometimes I forget what day, it is when I'm attending trial, reporting out a trial. But you did not know about any of the other murders until after the verdict.
Right. Yeah, I had no idea of anything else that she had been through prior to this trial, and even during the trial. I didn't know that.
And so
I think that's really it. Just want to make sure we got to. Yeah, I think we covered all the parts that are referenced in Trina K's motion. That's what I just wanted to make sure. So, I have some mixed feelings about all of this stuff. Having it be, my family members who are involved in this case. But I also see it from the journalistic point of view. I also see it from your point of view and from the public's point of view. I'm trying to look at it from all sides and just be empathic to each of the different parties in this situation. I get it. When it's your job, especially when, you're working for a channel, you've got a producer to please. you've got a station manager to please. They want you to go and run after those jurors and get those interviews, because if someone else gets it and you don't, your station's the only one that doesn't have it, you lose viewership and you lose, potential ad revenue and all that stuff. And so people's jobs and livelihoods are on the line. That being said, it would have been nice if the jury could have left without being mobbed. I think in Idaho, they did a much better job of protecting the jurors from the media and from the public in general. I remember Tom Evans saying that they parked at an undisclosed location away from the courthouse, and then they rode in a van to the courthouse, where they exited the van and immediately went straight into the courthouse.
And they moved parking lots several times too. They changed parking lots.
That's right.
And in Delphi, they were sequestered. They were put up in a hotel, probably in Lafayette, but it could have been Logansport. It could have been any number of places where they put the jury up, and they brought them in on a shuttle bus, and they actually put up screens so they could get into the courthouse without being photographed by the media. And the very first day, some photographers snuck in there and got some pictures, and the judge confiscated their cameras and took those photos from those journalists and protected the jury quite a bit better than what was going on here. But I have a picture that I went to share with you. That is my picture of that day of Carl and that fellow female juror being quote unquote mobbed by the media, because that was when everybody went running down there, and he said he heard the pitter patter of feet coming up behind him, and this little short guy, I don't know who that was, but I wouldn't participate, but I did come down to take this picture right here because it was impactful to me.
Oh, I've got to remove this other one. Sorry. There we go. Yeah. So this is the crowd. This is your picture, right, Joe, that you took?
Yes, that's me. Yeah. Yes, I took this picture of myself. Yes.
Yeah. So I can see at least 3 big station cameras and then cell phones everywhere. I mean, so many of these reporters, especially if they're from a smaller station, will have a station cell phone that they can record on for moments like this when they can't, get to the cameraman or whatever. So I agree. The court itself could have done a better job of protecting the jurors if they didn't want to be out in the public. And also the reporters could have left the jurors, let them go home and ask for interviews later. I actually had a very respectful journalist come up to me the first day I gave an interview right outside the courthouse with someone from Court TV, and actually Brianna Whitney, who interviewed Lori twice. They interviewed me outside the courthouse on the first day, and this very respectful correspondent from CBS came up to me and handed me his card and asked if it was okay if he contacted me. And I really appreciated that, because it wasn't just stick a camera in your face and, try to get what you can off the cuff with no preparation. And I will say, before I had a channel, I was very selective about who I would talk to in the media, and I always made sure to get references and to talk to other people about, hey, did you interview with this person? How did it go? Because there were some people that I frankly did not want to interview with, because I wanted to keep the sensationalism out of it, and to speak only about the things that I felt were beneficial to add to the conversation about healthier families, healthier religious systems, etc. So can you tell us, kind of from your perspective with this picture, what stands out to you?
That you can't see the jurors. All you see is the mob around the jurors.
Yeah.
Carl and Victoria are in there. They're the ones being interviewed, and you can look up online the interviews that were taken there, and you can see the little short guy that's in Carl's face. But so before this picture was taken, I'm sitting down in the media seating area. We're told that people are going to come out, so there's like 8 to 10, maybe 12 large media cameras set up in that media staging area you were talking about earlier.
Mm-hmm.
And there's like 12 microphones there all clumped together on that microphone stand. And then all of a sudden you see one guy go disappear down the sidewalk, and somebody else goes, "That's a juror. There's a juror. There's a juror." And then like 20 people go running after the juror too. And well, it wasn't 20 people once. It was like the first guy, and then like 3 guys, and then like 6 guys, and then like 15 people all running down to chase the jurors down. And I'm sitting there, I'm going, I'm not going to do it. I'm not going to do it. This just feels gross to me.
Yeah, I remember watching the verdict from here, and I actually did switch over to some of the various channels that had the juror interviews on there because I was curious too. But I also would have been fine with waiting to find out until, you know, they'd had some time to process. And I think, you know, somebody else pointed out too, Carl's an adult. He could have said no comment. He could have said not right now. You know, I think that's what I probably would have done. I wouldn't have been ready to talk about it right away. And I'm definitely the kind of person that like, I like to let it sit for a little bit and process how I feel beforehand, before I go and talk about it. So anyway.
Well, here's another interesting follow-up story to this. So 2 points. First of all, to the left here, left of that. No, you're fine. You're fine. To the left in that picture, is that crosswalk that you were talking about.
Yes.
Like 30, 40, 50 feet to the left is that crosswalk where they were caught again while they were waiting for their bus or waiting to cross the crosswalk, but waiting for their bus is where the Carl interview that we saw just a few minutes ago, that's where that was taken, was at that crosswalk, like 30, 40 feet to the left of this anyway. But right after I left this, so I'm sitting there baking in the hot sun. Nobody's coming to the microphone. I'm like, and they're down there. All of these people are mobbing these jurors. I'm like, I'm not going to go be a part of the mob, but I am going to go document the mob. And I turn around and start walking back. And I have 2 friends that sat in court with me that day. And they're pointing at me. They're going, and they're pointing down the sidewalk. And they're like, Joe. They're like trying not to say anything loud. I walked right past the other female juror. Yeah. I missed an opportunity, but I'm kind of glad I did, because after watching these, I'm not sure that I would have had the questions ready to go. Like after watching the interview that Lauren did, and after watching the interview that interviews that other people have done, I wasn't ready to ask the pertinent questions in this case or in any case. So it was a learning experience for me. It was all over a learning experience for me, but I'm okay with the decision not to be a part of that mob. I'm okay with that.
Yeah. And I think you made the right call. And I think I probably would have done the same thing. You know, as some people are pointing out here, that I would have been fine to wait until the next day or the next week, you know, when jurors are ready to speak. If they want to speak, they will. You know, even they could even reach out to media outlets. I'm sure that they had, you know, the ability to make those contacts if they wanted to. So, you know, I don't like the idea of just mobbing people and trying to catch them off guard. And I can tell you from experience a couple of times that I've been, you know, asked in the spur of the moment to comment on something. I don't really always have the best insight at that moment. And the more questions they ask, the more, you know, I sort of want to help shed light on some things, but I'm not always able to do it right there in the moment. I definitely am. I'm a much bigger proponent of letting things sit and wait a little bit. So yeah.
Yeah, and that's kind of a decision I have to make, like where I want to go. I've only been doing this. I say this since like last September, October, August, September, October, somewhere in there. So I'm still finding my path and finding how I want to do it. And there's a key decision right there in the moment. Do I want to be a part of that mob or do I not? And my gut just said, no, I don't. My heart said, no, I don't. I can't do that.
Yeah.
But when Nate goes jogging down the sidewalk, when Nate Eden goes jogging down the sidewalk, I'm like, what am I missing out on?
Yeah. And I kind of get it from the point of view that, you know, at least for me personally, especially, you know, this channel is about different things than just getting the sensational, being the first one to it. And I've said this a couple of times throughout this whole trial process, is that, you know, motions will come up, there's something to report on right this very second, I could jump on a live right then and there, but I much prefer to sit with it. And actually, I prefer listening to other people's perspectives first before I start talking about it, because I do want to consider other people's perspectives. The same thing happened when Colby posted his call with Lori. I waited quite a while before I talked about that. There have been a couple of things where I haven't, and I could have jumped right on with Lori's motion for a retrial as well. But, I was spending time with my grandbabies. So, I'm not going to ever be the one to scoop anybody else on something like that. McSpunky, good to see you. I'm so sorry that you're in the abyss of hell. Are you by any chance visiting the Estrella jail right now? Just curious.
Did you get portaled in there?
Oh, goodness. Okay, this is an interesting comment from Lee T. The bailiffs offered to escort all 12 jurors and took them out the side door. Tosh, Carl, and Victoria declined that.
I heard that. That confirms what I heard. Yes.
Yeah, interesting. All right. Good to know. Okay, so let's go ahead and get to Lori's ridiculous motion asking for a retrial. I just want to make sure that we covered everything that happened so that we saw that first before we dive into Lori's allegations and then Trina's response.
Well, before Lori's allegations, after. So Lori's allegations about juror misconduct were after this video that we just saw, Carl talking at the crosswalk, but before his interview with Lauren. So, yes. Okay.
Yeah. Thank you for pointing that out. Yeah. Thank you for pointing that out, because that's an important point. But apparently somebody emailed a clip of this juror's interview to the defense or the prosecution? To the defense.
Well, they emailed it to the court, and the court felt obligated to share it with the defense and the prosecution. So it was emailed, the YouTube clip, the video clip, whatever it was emailed to the court, to a member of the court.
Okay, got it. Okay, so here we are with Lori's motion for a new trial, and I'm going to ignore chat for just a minute while we get through this, because I don't want it to take forever, but I do want to make sure that we cover what Lori is asserting here. So we're just going to go straight to the facts. Juror misconduct. On April 28th, it came to the attention of this defendant's advisory council and later the court. Well, so she claims they received it first and later the court. Juror 15 made a statement indicating he had knowledge of the defendant's prior conviction. And then they cite the Fox 10 clip. He also indicated that he was leading toward a not guilty vote up until yesterday and through deliberations. This prior conviction involved the homicide of her children in Idaho in 2023. Thanks for reminding us, Lori. This defendant did not testify in this trial, and this conviction was not presented by the state as Rule 404B, other act evidence. Thus, Juror 15 should not have learned about this information. Because this case was a high-profile matter, once the jury was released from its admonition, jurors were free to speak with the media. During an interview, Juror 15 was asked about his reaction upon learning about this defendant's prior convictions. He stated the following, quote, I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell, unquote. So he
said lives, not lives.
Lives. Yeah. Lives. 3 lives. That is what he said. I want to go back though, because he indicated that he was leaning toward a not guilty vote up until yesterday and through deliberations. Well, we don't know exactly at what point he changed his mind and decided to vote guilty. And so this is a little bit of overstepping, I think, on the part of the defense team to say, he was definitely going to vote not guilty. And then he looked up the case and decided to vote guilty. That's kind of that's the stretch that they're trying to make there. And I don't think that's
right.
Yeah. And I don't think that that's reasonable to make that stretch, because they don't know at what point he changed his vote. And he actually said, I remember him saying, when he had more time to think about and clarify, I remember him saying that he was feeling not guilty up until the closing arguments. And he did vote not guilty the first time, and maybe even the first couple of times. But after reviewing those texts again, he said the text was the thing that did it, especially the one that said it was probably Ned before we got rid of him. And that was the text that I think kind of solidified his opinion.
Yeah, that sounds right to me. But I also have all three different interviews going through my mind, and I think maybe one of the other jurors said that too.
Yeah, could be. That could be for sure. And I did listen to Carl's interview. I listened to Tasha's interview, and I did listen to, was it Susan? Was that the other juror's name? Forgive me. She's the one who actually was raised in the LDS Church and had some background.
Is that Victoria?
Oh, Victoria. Yes. Thank you so much. And so it was one of those things where I just listened to it while I was doing something else on 2x speed because I wanted to hear it. So I don't have all the details. Normally I dig into this very, very deeply, but obviously had other things going on at the time. I think when the interviews were released, it was wedding weekend and I was furiously running errands all weekend long. So I didn't really listen very closely and take notes like I normally do. So I could be getting some of that mixed up. So anyway, then we have B, preclusion of Tylee Ryan and Alex Cox statements and impermissible expert testimony by Detective Daniel Coons. Prior to the trial, the court precluded this defendant from presenting to the jury any of Tylee Ryan or Alex Cox's statements. Both of these people were present during the shooting of Charles Vallow, and thus some of their statements were not hearsay as they show effect on listener pursuant to Arizona Rules of Evidence 8033. The state filed a motion in limine throwing a blanket hearsay objection over the entire statements. The court indicated in a pretrial ruling that it would, at least to Alex Cox's statement, take it on a statement-by-statement basis. During trial, this defendant was precluded from even discussing that Alex conducted a walkthrough, much less his statements with Chandler police detectives during that walkthrough. Well, Lori, that's because it was decided at the hearing where they addressed the motion in limine. And in my opinion, and I'm not an attorney, the time to address this concern would have been during that hearing. And an attorney who was prepared, who knew what they were doing, would have argued that at that hearing for the motion in limine. That's just my unprofessional opinion. What do you think about that, Joe?
You're not offering legal advice on your channel. What?
Yeah, I'm definitely not offering legal advice. Definitely not an attorney. And I'm just going to say, it's just my unprofessional opinion. Once again.
Yeah, I think Trina's going to have something to weigh in on that. So I'll leave that to her to weigh in on
I'm
that.
sure. Yeah, I'm sure.
Yes. Yeah.
Yeah. So then she goes on.
Response.
Right. Then she goes on. Then in the state's case in chief, it elicited expert testimony from the scene agent, Detective Daniel Coons. This defendant objected to his testimony as an expert witness based on lack of foundation and her not having had time to rebut his professional opinion. Yeah, let's wait and just hear what Trina has to say. She's the expert. Again, this defendant was precluded from discussing Alex Cox's, the shooter, thanks for reminding us, Lori, walkthrough that was conducted with several Chandler police detectives, including Detective Coons. This walkthrough was precluded as inadmissible hearsay. However, it formed the basis for Detective Coons' questioning with the medical examiner and how he then investigated this case, as Alex Cox indicated he shot the victim in self-defense. Well, I'm also going to say all of the other evidence pointed away from self-defense, so I don't think the walkthrough is anything material.
Well, I'm going to say, why didn't you present this evidence in court, lady? Like, you had a chance to present evidence and witnesses, and you didn't. So, who's that on?
That's on Lori. I'm going to raise my hand and say
lawyer Lori.
Yeah, lawyer Lori, the litigator. And then we have C, discovery violation. On April 14th, during the trial, Ms. Trina K. produced a hard drive containing the gray key information for Charles Vallow's cell phone. The contents of the hard drive are exculpatory evidence. Now that means, exculpatory means it's something that would just basically make it obvious that she didn't commit this crime. Am I correct about that?
Exculpatory means potentially clearing her of guilt.
Right.
Yes.
Right.
Inculpatory means it's evidence of her guilt. Exculpatory means it's evidence that could prove
exonerate her. Right.
Yeah. Exactly. Yes.
The defense had been requesting this evidence so that she could provide it to her independent expert for his review. This discovery disclosure occurred in the middle of the trial. Well, if I remember correctly, and correct me if I'm wrong, the problem with the gray key is that it's not something you can just put into a computer hard drive and read. You have to have the Cellbrite software to read it. And from what I remember happening in the trial was that Lori complained that they couldn't read it, and they brought this whole issue up. And then the judge basically said, sounds like user error to me.
Right, but it wasn't provided to her in original discovery. Like, I think this could be a valid point. This could be one of her valid points, because she was just provided with the Cellbrite extraction report, not the actual original data that led to the Cellbrite extraction report. Right. And when they did finally get that, which was sometime in mid-March, I think, so less than 30 days before trial, and she only had 10 hours for Lonnie Dworkin's time to extract it. It was like way too late at that point. And what was her investigator's name? Jeff White? Is that his name?
Jeff White. Yes, Jeff White.
Jeff White was trying to perform the extraction through Lonnie Dworkin's instructions. They're like on the phone for 4 hours one day, and he can't figure it out. And I'm like, just have Lonnie Dworkin do the extraction. Why is Lonnie Dworkin trying to walk Jeff White, who obviously is not a very tech savvy guy, through the extraction process? And they couldn't get it done. And that's when judge said, well, it sounds like user error to me. And I can't disagree with that.
Well, from what I understand, Lonnie Dworkin was out of town, and so he wasn't able to be there in person to receive the gray key and to upload it properly and read it and all of that stuff. But again, I'm just going to go back and say Lori was late with all of this. And so gray key or not, she was late asking for it. She was late noticing an expert witness. The judge was very patient in giving her all of this time. And eventually he said, it's going to be too late for this trial.
Well, yes and no. So I have to disagree with just a little bit, just slightly, on the fact that she asked for an expert, which had to be approved through the state funding process because she's an indigent inmate, back in January. And it took them until March 7th, which is less than 30 days before trial, to approve his 10 hours.
Yeah. Yeah. So I get that. It's also because Lori is 23 hours a day in this incarcerated jail prison situation.
Oh, yes. Oh my gosh. Yeah.
So, and it's so really hard to get to use the phone. And, this is why, Lori, most inmates do not represent themselves in their own murder trial. So.
Yeah. There's a thought.
There's a thought. All right. So going back to this, discovery violation was C, letter D, prosecutorial misconduct. Again, this is the second time, or at least the second time, maybe the third time that she's alleged prosecutorial misconduct, which is a serious allegation, by the way. Not something that most attorneys just bandy about. Most attorneys don't like to throw each other under the bus if they can possibly help it. But Lori seems to sort of enjoy this. On April 8th, 2025, the state elicited irrelevant, prejudicial, and improper character evidence when she asked Chandler Fire Department Captain Keller if he overheard any conversations with this defendant. Ms. Trina Kay asked Captain Keller on direct examination, "Did you overhear this defendant talking with police?" He responded in the affirmative, stating he overheard someone stating, quote, "not getting invited to pool party because of the commotion at the house or something," unquote. This statement caught this defendant off guard, as Captain Keller indicated during his interviews with Chandler Police just after this incident occurred that he only saw the male outside on the curb and did not mention even seeing this defendant. During closing arguments while addressing the justification defenses, Ms. Trina Kay told the jury that this defendant was not entitled to any of these self-defense instructions. Ms. Trina Kay also gave false statements by saying Alex had no reason to be at this defendant's home and that this defendant told Alex to bring a gun. Ms. Trina Kay knew from previous testimony interviews and pretrial defense interviews that Summer had begged Alex Well, if by begged you mean she sent him one text, then okay. To go over to this defendant's home because of Summer's concerns for this defendant's safety. We only saw one text in evidence. I guess there could have been more text than that. There could have been a phone call that we didn't hear exactly what was said. Finally, Ms. Trina K commented several times on this defendant's demeanor during this incident, drive to the police station on the body camera, and told the jury, quote, "You did not see her cry in that interview." Yet knowing there were portions of this defendant's interview that had been cut from the full interview admitted by the state where she sat in the room and did show emotion, can be seen grabbing a Kleenex.
She grabbed a Kleenex. Oh my God, she's innocent. She's
That's
completely
right.
not guilty. She grabbed a Kleenex. Oh my gosh.
Yes. As we all know, in case precedent, if you grab a Kleenex, it means you're not guilty. If you grab a Kleenex, it means definitely not that you have to blow your nose. Definitely not that you're making a show because you know you're being recorded. But it definitely means that you're not guilty.
Well, and she's citing what Trina K says in her
Right.
closing arguments, and the judge has admonished the jury that that's not testimony. What the attorneys say for either side is not testimony. You cannot consider that as evidence. So she's trying to say she said something that's not in evidence, but
Yep.
that's another point. Just a minor point. I'm also
Just
not
a minor
an attorney.
point.
Yeah.
Yeah. So I'm just being a little bit snarky here. And then
She brings
Lee
it
T,
out. She brings it out,
definitely.
doesn't
She does. Lee T has another good point here. That's rich coming from Lori, who filed a prosecutorial misconduct motion naming Trina K's boyfriend
she? Mm-hmm.
and
Right.
citing his potential unethical behavior having nothing to do. And what she alleged in that motion was that Trina K's conduct is not original, meaning that she got it from somewhere. She must have gotten it from her boyfriend.
It's contagious. It's
is
contagious.
what she said in that motion. Yeah, just
Oh my
ridiculous. I mean, I realize when you don't have a defense at all, you've got to do something, but it would have just been so much easier if she would have testified. Anyway, moving on. So yes, that portion of the interview that was cut is Lori sitting more still than I've ever seen a person sit in my entire life after she's just been interviewed following the shooting death where her brother killed her husband, and she is completely calm. I would bet her resting heart rate at that moment was probably somewhere in the high 50s, if that. And she does reach for a Kleenex, and I think she dabs one corner of one eye, and then she just sits there and holds the Kleenex. So I didn't really think she was crying at that point. I could be wrong. I know that those cameras aren't super high def, but
well,
anyway.
Alec Murdaugh in that case out in South Carolina, he cried and sniveled quite a bit, and we're pretty sure that he's probably guilty because he's been found guilty of murdering his wife and son.
Yeah. So that's the other thing to point out is that a lack of emotion doesn't necessarily mean guilt, and a presence of emotion doesn't necessarily mean innocence, because
Exactly.
people do grieve in different ways. People do show their emotions in different ways. And lots of times people who are guilty are very sad about it because they're very sad that they got caught and they're going to prison. And so their tears are not for the victim. They're not tears of remorse. They're tears for themselves. I'm just going to cite a Marvel movie on that one. No, I won't get into it, but one of my favorites is, the tears are not for you, they're for him. Anyway, we can talk about that later. Okay. So, court's lack of impartiality. The court precluded this defendant from presenting a defense by striking her witness, including but not limited to Nate Eaton and Brandon Boudreaux, also spelled incorrectly, before they were even called to the stand. Specifically, before testimony began, the court required this defendant to establish on the record what relevancy her witnesses would present. This required this defendant to state in front of the prosecutor her defense strategy. No, you didn't have to put your whole strategy out there. Just had to make a general statement. I'm going to question this witness about communications he might have had with the victim. That's all she had to say. And then Trina K would have interviewed him and found out he didn't have any, it would have ended up in the same thing. But she did not have to reveal her entire strategy. Again, she is a victim in this process, a victim of the big bad state who wouldn't allow her to put on a defense, as we heard her say in her interview just after the verdict. This is not required under the law or any rule of evidence. During cross-examination of a civilian witness, Serena Sharp, in relation to testimony regarding religious beliefs, the court commented during the prosecutor's objection to relevancy, stating, quote, "I guess to the extent that you're comparing yourself to these biblical figures, I will allow it." That was one of the most bomb drop moments, I thought, in the entire case. And Judge Boresky's delivery of it was so dry that I had a hard time not giggling a little bit when he said that. I guess if you're going to compare yourself to Abraham and, whoever else got translated, go ahead. Part of the state's case was to establish that this defendant had stepped outside of the Mormon religion by claiming she was a translated being, specifically in text messages saying she would be like Nephi, and that these messages were nothing more than part of the conspiracy to kill Charles Vallow. Now, is this your highlight, Joe? Did you highlight it or come like this?
It would be my highlight, yes. I don't remember highlighting it, but but it definitely didn't come like that, no.
Okay. This defendant attempted to establish that being translated was a regular part of the Mormon religion and thus a relevant line of question. Now, let's talk about this for just a second. Is being translated a regular part of the Mormon religion? I'm going to say my 2 cents on it, and then I'd love to hear your take as well. I will say yes. Generally speaking, mainstream LDS, members of the LDS Church, members of the Church of Jesus Christ of Latter-day Saints do believe the Bible to be the Word of God as far as it is translated correctly. And we know that there were a couple of people in the Bible who were translated. Lori made reference to a couple of them. So yes, generally speaking, Mormons do believe that there is such a thing as translated beings. In the Book of Mormon, there's reference made to 3 people who were apostles of Jesus Christ when he visited the people on the American continent. Those 3 people are referred to as the 3 Nephites. Before Jesus ascended to heaven, he asked his apostles what they would ask of him, and some of them did ask to be translated so that they wouldn't taste death. These 3 beings asked to remain immortal and stay on the earth until the Savior came again so that they could help do things behind the scenes, I guess. I don't want to be disrespectful of those beliefs, so I will leave it at that. But just to say, yes, in the Bible and in the Book of Mormon, there are beings who are translated, meaning that they're immortal and that they can't be harmed, essentially. However, most mainstream LDS people don't believe that they personally can become a translated being just by visiting the temple and saying some ritualistic words. That's my personal take on it. What do you think, Joe?
So I remember growing up, learning about the translated beings and thinking, and this may not be accurate, but McSpunky, look at that.
Thank you, McSpunky, for gifting 15 memberships. That's amazing. We appreciate you.
I remember growing up believing that to become a translated being, you had to be basically a perfected being on this earth before you could be translated. So you had to have all of your sins forgiven and washed of you, and you had to have all of your whatever steps you had to go through to become a perfected being before you could become a translated being. Does that sound right to you?
Yes. What I remember is that the people in the Bible who were translated beings were super, super righteous and super old, super wise,
Yes.
had been through a lot and had proven themselves faithful to God. And then, just like they had to be forgiven of all their sins, if I remember that correctly.
Yeah, they had to be almost superhuman.
Yeah,
which makes the doctrine of the church it turns it into a defeatist religion, because we're never going to get there. We're never going to be perfect
in
on
this
this
life.
earth.
Yeah,
Ever.
yeah.
Ever.
And then I remember the city of Enoch, right? The
Yes.
whole city got taken up into heaven because everybody in the city was so righteous. So, yeah, it's a little problematic. Somebody asked a relevant question, and now I can't find it because there are so many. Okay, Nina Canadian, respectful question intended. If translated beings are immortal, why aren't they still alive today? Well, the idea is that they went from mortal to immortal in the twinkling of an eye, is the phraseology, if I remember correctly, that they were translated directly into immortal beings, so they never had to taste death, or in other words, they didn't have to feel the pain of death, and then they went straight to heaven. So the three Nephites,
or they could still be on the earth today. There could be some.
They could be, I guess. But this adds another layer of spookiness to me, to the religion, to think that. And let's be clear. Every time that the missionaries gave a lesson where they talked about the spirit world, they would say the spirit world is here. There are spirits all around us, both good and evil. So these are part of mainstream Mormon beliefs. I don't want to get too far down the rabbit hole here, but I just wanted to say, I mean, it's super confusing. A lot of it is contradictory. It's hard to follow. The bottom line to me is that regardless of translated beings or whatever, most mainstream LDS members do not believe that they personally can be translated, because you have to be super, super righteous to do that. And none of us are. And then the other part of it kind of is, seeing Jesus in the temple, that she told Adam she saw Jesus in the temple. She said that she was married to Moroni in a past life. And for those who aren't Mormon, Moroni is the gold dude who is wearing a dress, blowing a trumpet on the top of every temple, or most of the temples. So when Trina K referenced
the gold dude in a dress blowing a trumpet, I love it.
On the top of the temple, yeah. So when Trina K referenced this in I believe it was Serena Sharp's testimony, she asked, did Lori think that she was married to someone significant in your religion? And Serena said, yes. I think Trina didn't want to go down that rabbit hole by explaining who Moroni was and everything, but that's what Lori was saying, is that she was married to Moroni in a past life.
And didn't Lori also claim that she received the priesthood from Moroni in the temple? Wasn't that one of her claims?
I believe that was one of her claims, and she did tell Adam that that her priesthood was higher than the priesthood of anybody on the earth, basically.
Yes.
Even a prophet, right? So
higher than the Melchizedek priesthood.
Right. So yeah, and actually, if I remember correctly, Lori also said that Jesus presided over the sealing of her and Chad. Am I remembering that correctly, or was it Moroni? Moroni was the one that married Lori and Chad. I don't know. They made it all up, guys. Just spoiler alert.
What? They made it all up. What? That's crazy talk.
It's not real. It didn't happen. She did claim to be a goddess. So there's that. So anyway, let's get back to reality, shall we? For a second, just for a second. It's hard in this case to do that. Let's see. This defendant attempted to establish that being translated was a regular part of the Mormon religion and thus a relevant line of questioning, which I think we've established that it's not. So I think she felt like Judge Boreski was making fun of her, which maybe he was a little bit, but he was perfectly within his professional conduct to sustain that objection, or to overrule Trina K's objection, in order to allow Lori to compare herself to these biblical figures, because that's what she wanted to do, and it was relevant to the case. So, number 2, argument and authority. Arizona rules of criminal procedure provide that a court may grant a new trial when a juror or jurors have committed misconduct by receiving evidence not properly admitted during the trial. Additionally, a new trial is appropriate if, for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. That's a pretty broad rule. I'll wait for Trina K's explanation.
Right.
This defendant is entitled to a new trial because the jury received and consulted extraneous evidence. Once a defendant shows the jury received and consulted extraneous information, prejudice must be presumed, and a new trial must be granted unless the state proves beyond a reasonable doubt the information did not taint the verdict. So I think it's up to the judge, right, to make that determination. But again, I'm going to wait for Trina K.
Well, here's a logical argument. Juror number 15 is outside saying that he felt sorry for her the day before, and he
Right.
shouldn't have known about her 3 life sentences the day before, and he still voted for her guilt. So
Right.
how did that taint the jury? Like, if he felt sorry for her, then he should have voted not guilty, right?
Yeah. So true.
Logic.
It's-
Lori's
yeah,
logic.
Yeah, there is nothing logical about Lori's argument. And again, I've said so many times, it's a bag of cats up there, and trying to understand it is going to get us nowhere. But at least we can try to understand what she's saying here, even if we don't agree with
Right.
with whatever it is she's trying to argue. So then it goes on to say, in State v. Poland, the court held that since the federal convictions were based on the same series of acts as were at issue in the state prosecution, evidence of the prior convictions is inherently prejudicial. When a juror does not base his verdict on evidence developed at trial, he violates the fundamental integrity of all that is embraced in the constitutional concept of trial by jury. Such misconduct by jury members denies the criminal defendants their rights under the 6th and 14th Amendment to confront and cross-examine his accusers about that extrinsic evidence. This defendant's advisory counsel and the court both received evidence that the jury's verdict was tainted when Juror 15 spoke during his interview with Fox 10 News, disclosing that he had learned of her prior conviction seemingly one day prior to the admonition being lifted. Because it is clear Juror 15 had information he was not entitled to know prior to conducting deliberations, the burden is on the state to prove beyond a reasonable doubt that this information did not taint the verdict. The state will not be able to meet this burden. That's a presumption. And this defendant is entitled to a new trial. Well, they have to have the opportunity to meet that burden.
And they will. And so remember this paragraph, folks, because when we get to the state's response to this motion, they're going to address it. And it's interesting how she addresses it. Obviously, she cites Lauren's interview with Juror 15 and a couple of other things, but just remember this paragraph.
Yeah, it's important. Okay. C. Cheadle says, Megan, last night was fun. What are you talking about? That's weird. Why would you bring that up right now? That was a personal thing. I'm just kidding. I was on Web Sleuths for a little bit last night.
I was like, wait, what?
For a second, I was like, what did I do last night? Like, did I go live without knowing it in my sleep? Okay, so let's see. State will not be able to meet this burden. Yeah. So even if an offending juror may not have influenced the other jurors, unanimity is required to convict a criminal defendant, and the juror's conclusion may have been different had the juror not consulted extraneous sources. In Cornell, a juror looked up definitions that were neither admitted into evidence nor included in the trial's court instructions. The juror testified that he was confused and undecided about the allegations, and his reference to outside sources made his decision that the defendant was guilty. Reference to a dictionary definitions by jurors is usually considered a harmless error. However, the appellate court found that this was not a harmless error and that the defendant was entitled to a new trial. Sorry, my lips are super chappy. Similar to the juror in Cornell, Juror 15 stated he had information neither admitted into evidence nor included in the trial's court instructions. Even more egregious than in Cornell was that this information learned was that this defendant had prior homicide convictions. I agree, that's pretty serious, Lori. Thanks for reminding us. As in Poland, this information is inherently prejudicial as these prior convictions directly related to this prosecution. At the time of the writing of this motion, it is not known if Juror 15 shared this information with other jurors. However, what is clear is that Juror 15 did not follow the admonition and notify the court of him having learned of this information. So an inquiry could have been conducted, should have said inquiry could have been conducted, not conducted been, prior to deliberations. These actions directly violated the court's instructions and could have factored into Juror 15's verdict, if not multiple jurors' verdicts. In fact, Juror 15 noted that up until the day of closing arguments, he would have voted not guilty. Given this, so with saying all of that, she just undid her own motion by saying, Juror 15 noted that up until the day of closing arguments, not after that, up until closing arguments, he would have voted not guilty. Given this, the state's unable to prove that Juror 15's misconduct did not taint his and potentially other jury members' verdicts. The state will not be able to overcome the overwhelming evidence of Juror 15's misconduct in order to prove beyond a reasonable doubt that Juror 15's misconduct did not taint the jury. Accordingly, this defendant is entitled to a new trial. And then we're going to go to preclusion of the statements. A new trial is appropriate if for any other reason, not due to the defendant's own fault, the defendant has not received a fair and impartial trial. We're going to use that one again, huh? By precluding Tylee Ryan and Alex Cox's statements, this defendant was prevented from presenting part of her defense at trial, and thus she did not receive a fair and impartial trial. The court made a pretrial ruling that at least to Alex Cox's statement, it would make a statement-by-statement ruling. Instead, this defendant was even precluded from discussing Alex Cox's statements during his walkthrough. These walkthrough statements formed the basis for Detective Coons being able to testify as an expert, yet she was precluded from cross-examining him on this foundation. For this basis, this defendant is entitled to a new trial. So I don't know.
I do remember that in the pretrial hearing, the judge said he would decide on a case-by-case basis, and he did not allow anything in during the trial. So,
right. And I think that's largely because the state objected each time Lori tried to bring that up. And if Lori were a competent attorney, she would have reminded the court that they offered to take the statements on a case-by-case basis. They could have possibly had a sidebar. You know, it would have been up to a competent attorney to correct the court and to say, hey, you said you would do this case by case. Can we talk about this? So anyway, I forgot what I was going to say, so we'll just go on. Oh, I was going to say, she's repeating the same thing that she said before, and I know that when during this section of the motion that they do have to cite the reason that they're asking for a new trial, but I don't know if it's usual for an attorney to just restate the entire thing that they just said. Normally, I think what happens, and I could be wrong about this, is that they present the case law that supports their argument, and then they tie the argument to the previous statement rather than just restating the thing. But that's right. I could be wrong. And then C, discovery violation that occurred in the middle of trial. Entitle this defendant to a new trial. Discovery rules are designed to implement and not impede the fair and speedy trial rights. On April 14th, during trial, Ms. Trina K. produced a hard drive containing the gray key information for Charles Vallow's cell phone, '(S), possessive, please. The contents of the hard drive are exculpatory evidence. That's your opinion. Defense had been requesting this evidence so that she could provide it to her independent expert, maybe? Is there a word missing? The state's discovery violation is 1, the importance of the evidence which the defendant was deprived cross-examination, the right to confrontation, proper investigation, and examination for defense, and 2, the state manifested the surprise and prejudice to the opposing party. 3, the violation was motivated by bad faith, which neither the court nor the state corrected, and 4, the many other relevant factors that the state saw fit to deprive the defendant of her constitutional and statutory rights. I'm just editing as I go. It's just how my brain works. And then D, acts of prosecutorial misconduct entitles this defendant to a new trial. A new trial is appropriate if for any other reason, blah, blah, blah. Okay. The statement elicited from Captain Keller was irrelevant and prejudicial to this defendant, yet Ms. Trina K. purposefully asked this witness if he overheard any statements. Well, I don't remember. Did Lori object? I don't think she objected.
No.
She
Nope.
addressed it on cross, but she did not object at the moment that this statement was made. At the moment the question was asked, the statement was made. Lori did not object. That would have been her opportunity to have that stricken from the record and taken out of evidence. Second, it's improper for a prosecutor to misstate the law or evidence during closing arguments. Ms. Trina K stated this defendant was not entitled to self-defense instructions, yet they were clearly provided to the jury. Ms. Trina K also gave false statements in her closing statement, blah, blah, blah. So we've read all of this before. Lastly, commenting on this defendant's demeanor, specifically stating this defendant did not cry during her police interview. So again, the judge covered this. Closing statements are not evidence. Lori also got to give her closing statement, and she didn't mention anything about this in her closing statement, which
She
again,
didn't address the evidence will show. The evidence will show.
Right,
The evidence will
right.
show.
That's what I kept expecting her to come back and say the evidence has shown 72 times,
Right.
followed by what she thought the evidence showed. Right.
Hmm.
So there, statements, closing statements are not evidence. And she could have said, if I were an attorney, I would be taking notes during the state's closing statement so that I could say, Trina K alleges that I didn't cry, but she didn't see the whole interview. I would have addressed some of that. But anyway, that's neither here nor there.
We might be better armchair lawyers than poor Lori. We might be.
Yeah, I mean, I hope I'm never in the position that I am being prosecuted for a crime. But if I was, I would never represent myself. Like, not ever. There's really
what Abraham Lincoln said, right?
Yes. Was it Yeah, it was Abraham Lincoln who said, "Go ahead."
He who chooses to represent himself has a fool for a client.
Right. I couldn't think of the right wording in the moment. Yeah. She, in this case, Lori certainly does have a fool for a client. So then, judge commenting on the evidence during this defendant's cross-examination showed a lack of impartiality and entitles this defendant to a new trial. While under the law, trial court is presumed to be impartial and free from bias, this defendant can rebut this by the preponderance of evidence by showing the court required her to present her defense strategy to the state before calling any witnesses. They did not require her to present her entire strategy. That was an assumption that Lori made, and it's just too bad. Let's see. Other than the defendant intends to call as a witness in trial, name and address of each person, and any written or recorded statement. There's nothing in Rule 15.2 that requires this defendant to present her defense strategy in order to call witnesses. The Fifth Amendment of the United States Constitution provides this defendant the right to subpoena power. This preclusion of witnesses and requirement of this defendant to inform the state of her defense prior to calling any properly noticed witness shows a specific claim of partiality. Second, for the record, established that the court commented while responding to the state's relevant objection, and that comment showed a specific claim of partiality by casting doubt onto this defendant's credibility on this religious issue, and in general showing she cannot be trusted. I don't think that was what happened at all. But I'm not delusional, so maybe we just disagree on that one.
Can we agree to disagree with the defendant?
Yeah. The court commenting to a relevancy objection, I guess to the extent you're comparing yourself to these biblical figures, I will allow it, can be seen as injecting his own opinion. I don't think that was the case at all. This comment is even more important when taken into consideration that Juror 15 in the Fox News 10 clip indicated he ultimately made a decision to vote guilty based on 2 text messages, including the one describing "I will be like Nephi," which has nothing to do with translated beings or with the testimony being given or with the judge's comment. That's my own commentary there. The court inserted his own improper comment when a simple overruled or sustained was warranted. No, he was clarifying that he is overruling the objection because you're comparing yourself to the biblical figures. I think he was trying to prevent her from going deeper into describing herself as a translated being.
He actually ruled in her favor because the objection was by the state, and he overruled the objection by the state. So You go, girl. You go.
Yeah, so she's making this appeal based on an objection that was ruled in her favor.
Yeah.
So I'm just going to sit with that for a second. Okay, so now let's go to Trina K's response. So Kikaru is asking, I hope I'm saying that correctly, how long before the judge has to decide? Oh, thank you. Or rule on this motion. I believe that probably there's going to be some discussion at least on this motion at the final trial management conference on May 14th. It's hard for me to believe that we're in May already. It's been a blur. But yeah, I think we'll at least hear some discussion about it at that conference. And the Dunning-Kruger effect is just this effect that the very thing that you need intelligence-wise to know whether or not you're good at something, well, the thing that you need to be good at something is also the thing that you need in order to know whether or not you're good at something. And so that's why you get all of these American Idol auditions with people who think that they're excellent singers because they lack the understanding to know that they suck at it. And I think that's what we're seeing here with Lori being an attorney. So,
don't go on America Represent Yourself.
Right. America's top attorneys, America's wannabe attorneys. And by the way, I'm going to do some discussion about this because Lori's dad, Barry, represented himself in a case where he was accused of making false statements to the IRS. In the late 90s, he pled guilty ultimately, and he was ordered to serve 1 year and 1 day. He did serve time in prison. And he also later on wrote a book about how the American public can dismantle the IRS. And if you read even a snippet of that book, first of all, you'll probably fall asleep, but then you'll also understand, I think the language in Lori's motions has changed over the course of the trial. We saw in her first handwritten motions that she would write in all caps. She would underline things. This is the kind of emphatic language that you see Barry use in his book and also his motions. So he pled guilty. He served that time. Then he later went back and sued the IRS and the United States federal government and lots of other people, basically claiming that they had no right to put him in jail. He ultimately lost those lawsuits, but I'm going to do a whole episode about that just because I think it's important for people to know where Lori gets some of her ideas and where she possibly gets some of the way that she talks about things in court, etc. So ahead of the next trial, that'll be coming out. Let's see. I want to add to the stage, bringing to the stage now, Trina K's response.
Oh, I thought it was going to be Trina K. I thought Trina was coming on with this.
I wish. I would love to have her on, Trina K, if you're out there or if any of your staff is out there. I would love to interview you for the Midlife Revolution podcast. I am a big fan of your work. And I think this is the wrong one. So I'm going to remove that one and add this one. There we go. Oh, wait. Nope, that's the wrong one. Remove that one. Do I have it up here twice?
You're changing
Face response.
writing.
Okay, I got it. Okay, it took me a long time to put the Barry episode together because I had to kind of forget about family stories and look at actual documents to make sure I had the right information. So it took me a while. I've got the timeline down and I'm ready to go. So I'll probably record it within the next couple of days or so. Okay, so this is the state's response. Requesting the court to deny the defendant's motion for a new trial as there was no juror misconduct, no prosecutorial misconduct, no improper exclusion of hearsay testimony, and no lack of impartiality by the court. The state's response is supported by the attached memorandum of facts and authority. So
Bring
after the verdict,
facts.
yes,
Bring the facts.
I'm excited for reality now. I've had enough of delusion. After the verdict, the jurors were released from the admonition and had to face a mob of journalists questioning them as they waited for the bus to take them to their vehicles. Juror number 15 was one of the jurors who was caught by the media. Juror 15 made multiple statements that were recorded by multiple agencies. Video on YouTube from Idaho News On Demand shows the first contact by the media with Juror 15 as he was exiting the South Court building. In this video, there are multiple media agencies rushing to Juror 15. It's clear from the fact that you see the media running up to the juror that this encounter with the media occurred before the video cited by the defense, which was conducted next to the street bus stop. In the initial media contact, one of the media asked Juror 15 and another juror, were any of you folks aware that this woman had already been convicted of 3 homicides? Juror 15 responds, no, I did not. So let's look at that video, because I forgot that there was a video, the East Idaho News one, and I don't readily have it up, so I apologize. It'll take me a second to find it.
Yeah.
I tried to click on the hyperlink in the document and then remembered it was a PDF. So
I can get to hyperlinks from PDFs. You can?
Oh, can you? Well, I can't.
I think you have to
sharing it.
you have to hold the control button down, I think.
Oh, okay. Well, also maybe I was not holding my mouse right. Let me try that. Nope, that didn't work. That just advanced the slide. Nope.
So my comment while you're working on this is, he said multiple things and some of them are contradictory. So
yeah,
if I'm the judge, I'm just going to call him in and say, hey, can you clarify exactly what's going on, buddy? What's going on now? What went on then? Just for the record. We need this for the record. And by the way, for the record, Maricopa County Superior Court, you need to get your jury stuff together. You need to have a way to isolate them. But that one comment we saw earlier was, the bailiff said, if you want an escort, we'll give you an escort and you don't have to talk to any media. And those 3 jurors in particular declined that. But the bailiff, there were 2 bailiffs out there with them though, but they were just trying to kind of make sure that it didn't get out of hand. They weren't keeping them excluded from the media. But obviously we didn't see any of the, let's see, 3. We ended up with 14 and we saw 3. So the 11 other jurors, we didn't see anything from. We saw nothing. So these 3 may have voluntarily subjected themselves somewhat to this mob and to being interviewed. And we did see them interviewed. We did see them interviewed beyond outside of the South Tower. We saw them interviewed after that with Lauren or whoever they went on with after that.
Right. Yeah, that's definitely true. So I'm not immediately seeing the live where Nate Eaton was talking with the jurors outside. And I think this was on Verdict Watch, if I remember correctly. So I'm just give me a minute to see if this is the correct. Yeah, I think this is that's the Jerry Vallow interview.
This video, there are multiple media agencies rushing up to Juror 15. Yes, that's true. It is clear from this fact you see media running up to the juror that this encounter with the media occurred before the video. Okay, it doesn't matter when he said what. He said conflicting things, contradictory things. So let's just clear it up. I will take him at his word. After his interview with Lauren, I am taking him at his word, and I am believing that he just misspoke.
Okay, I think I found it.
Walk and talk.
I can do that sometimes. Okay. Right now my brain is not there. I'm going to share this tab instead. Can we see it? Add to the stage. I have to remove this one first and then add this one. I'm getting the hang of it, you guys. I'm working on it. Okay, so here's the video that they're talking about. You can see Carl right here in the bright blue shirt.
Mm-hmm.
And this is the court TV reporter that I spoke to. I recognize her, but I don't recognize anybody else. But there are quite a lot of cameras here. And this is before, so the crosswalk, you can see this sign right here points to the crosswalk is over here behind this cameraman. So this is before they get to the crosswalk.
Yeah, this is right before my picture that I took. Remember that picture that I showed you?
Yeah.
Here we go.
It was all about the evidence, really. You know, I mean, that's what it always boils down to.
Yeah.
It's just the evidence, text messages.
Can you pump up the volume just a tad?
That's what I was going to ask. Was there any specific evidence that you guys, the text messages?
There we
Which
go.
one in particular? Anything that stuck out to you guys?
So I'm going to fast forward because
I'm
it's
sure
not
I should
until.
say anything else because
Yeah,
I
Carl,
just
you
got
shouldn't
right
say
now.
anything
I
else.
say they're guilty or not guilty. What does she have to lose?
The other juror is standing right behind him. Do you see her? She's standing there. She has the chance to go over to the bus stop, and she's not. She is standing there.
Yeah.
She is subjecting herself to this mob. So I'm sorry, but she wants to talk. And actually, when she got interviewed, somebody told me she's trying to process all of the things that she found out about Lori afterwards, and she wants. So she's voluntarily standing there while he's being interviewed, and eventually she gets brought into this interview as well. But if she's standing there like that, she's a voluntary part of this. So nobody can tell me that she was involuntarily mobbed. But that's okay. That's her choice. She can do that
if she wants to speak. Yeah. And also, you know, sitting there in the courtroom all day, every day, hearing this evidence, not being able to talk to anybody about it. Finally, they do get a chance to talk about it. I completely understand wanting to offload some of that steam. But yeah, when he said it right there, he said, I maybe shouldn't say anything else because I don't want to have a mistrial. Yeah, maybe we should have.
He's the one that said it first. He said mistrial first.
Yeah, but I understand, you know, when they're right there and, you know, they're asking you these questions, it's a high pressure situation. So I don't fault him. So here we go with what he actually said.
Okay.
That Trina K references.
No, I did not.
And nobody brought it.
And ma'am, would you want to come in and talk too?
I'll back it up just a little bit because the question is important.
Homicides.
Yeah, no,
And
I've
the
never
jurors
heard of
did
her
not know
before.
that.
No, I did not.
It's hard to
What does she
hear.
have to lose? You know, it's guilty or not guilty. What does she have to lose? So
Were any of you folks aware that this woman had already been
I had never been
convicted
heard.
of
I've never heard
3
of her.
homicides?
Yeah, no,
And
I've
the
never
jurors
heard of
did
her
not know
before.
that.
No, I did not.
And
I
nobody
don't
brought
think
it.
you did
And
either,
ma'am,
no.
would you want to come in and talk too? Do you want to say anything?
Just,
Yeah, what was your
there's a lot of backstory here, and this woman had already been convicted of 3 homicides. And they obviously didn't want you folks to know that. And nobody knew that during your deliberations.
No.
Is that correct?
No.
Correct.
Well,
Okay, so she says correct also. Just clarifying. So the reporter that was actually asking them that question, I got a chance to meet him. He is a longtime reporter from the Arizona area, in fact, and was asked to cover this case. He seemed to be a very serious and respectful person. Did you get a chance to meet him, Joe?
I did. Yes. Same impression.
Yeah.
Yeah.
So anyway, it's a hard situation. It's easy for us to sit here and say what we would do. I mean, who knows?
Yep. Just as like a person who was there at the time who was trying to provide some type of insight into this case, I had my own internal things that I was struggling with. I cannot imagine what those jurors are internally struggling with at that point in time.
Yeah. Okay, so let's go back to Trina's response here. So she references this video, multiple people rushing up, and the reporter says, were there any of you folks aware that this woman had already been convicted of 3 homicides? Juror 15 responds, no, I did not. Juror 15 and another juror are then asked, there's a lot of backstory here, and this woman has already been convicted of 3 homicides, and they obviously didn't want you folks to know that, and nobody knew that during your deliberations. Is that correct? Both juror 15 and the other juror both say no, and this was prior to, again, the video that Lori references. Juror 15 was very clear in this immediate contact with the media that he did not know about the defendant's prior criminal history prior to reaching a verdict. A few days after the verdict, Juror 15 participated in an hour-long interview with Lauren Matias, spelled incorrectly, unfortunately, Lauren, for her podcast, Hidden True Crime. And then she includes the link there. In that interview, Juror 15 states that everyone was respectful of not telling him anything about the case when the trial was going, and that if anyone would have, I would have put up a hand.
So just let me comment real quick before you keep going with this.
No, please do.
This is all well and good, but this isn't any different than Lori citing the other interview in her motion. It's all TV interviews. It's all
right.
Social media interviews. I need to know a legal response that Carl has to this question. How did you know why did you say that on that one clip? Why did you say that? And I already told you there's only 3 options to that. I want to know which of those 3 options is true. And I want the judge to ask it, and I want him to provide a response to the judge. Then I'm over it. I'm completely over it. Yeah. There's no mistrial. There's no retrial. We're just moving on.
Yeah, I agree with you. And I'm not, by the way, pointing out errors in order to say that I'm, without error. Certainly, I'm not trying to, shame anybody. I'm just saying that I'm just pointing it out so that people are aware of the error.
You have typographical OCD like me.
I do. I have somewhat of an eidetic memory, and it just jumps out to me. But also just for the sake of, of getting things correct. And Jamie Keys is asking how I'm related to Lori. My dad is the brother of Lori's mom. So Lori's my first cousin. Welcome. You must be new to the channel. So welcome to anybody who's here for the first time, of course. And also welcome to all of my subscribers and watchers who've been here since the beginning. I appreciate you guys. This case is one that is complicated for me and my family, and it helps me to be able to talk through these things and unpack them here on the channel. In addition, though, my main message is about trying to help people to find healing and to have healthier communication with their family and to have healthier religious systems so that we don't end up having similar cases and similar things happen in the future. So my focus is on healing and on helping people to process their trauma. I'm related to Rex. Rex is my uncle. Rex is also my dad's brother. So that would be, Rex is just my regular old uncle. So yeah, I appreciate you asking. I know there's probably more than just you, Jamie Keys, who doesn't know, who don't know how I'm related. And it's confusing because cousins can be confusing too. There's first cousins, second cousins, all that stuff. So Lori is a year older than I am. Summer's a year younger than I am. I used to hang out with the Coxes in the summers. Lori and I lived together in Austin for a short time, and she was a bridesmaid at my wedding. And we were pretty close up until the time when she was divorcing Joe Ryan around 2005-ish, 2006 timeframe. And the Coxes, actually, Janice and Barry lived here in San Antonio for about 10 years. And our families were very close during that time. We did all the holidays, birthdays, all of that together. And during that same time, Adam was living in Kansas and Summer was living in Arizona. So neither of them were here in San Antonio. And sometimes they like to say that I wasn't close to the family, but they forget that for those 10 years, we went to the same church, we went to the same temple, We, hung out during holidays, and my kids swam in Janice and Barry's pool all the time. And my oldest daughter and Lori's oldest son, Colby, hung out quite a bit until they were in their preteen years. So there's all of that info for you guys. All right. So going back, just pointing out that, yeah, Trina K is referencing this other video, this other interview. None of this is on the record, right? None of it is in front of a judge. There's no court reporter.
Nope.
So it's hearsay, really, at this point, until the judge interviews this juror. And hopefully he'll do that prior to the hearing on the 14th, or the trial conference on the 14th. I will be really interested to hear how this plays out, because I think it's important for the judge to interview this juror,
Yeah.
and probably all the jurors, just to be safe.
We have 2 motions on the record, so it's going to be up to the judge how he responds to the 2 motions.
Yeah. So we went through this earlier in the video where we actually played this clip, but Lauren says it's the day of the verdict you learn. So is that what you quickly Googled on your phone and you saw before you walked out of the courthouse? He says, yeah. Lauren says that there were other murders. He says, absolutely. Lauren says, so you learned right then. Juror 15, hum. So he basically says, During the interview, Juror 15 talks about not wanting to talk to the media when he left, but all of a sudden he was surrounded. And Juror 15 was asked directly by Matias about whether or not he knew about the other murders prior to the verdict. And that's when Lauren says, but to clarify, you don't know how you knew there might have been another sentencing. Everything's a blur. I do understand that. Sometimes I forget what day, it is when I'm in attending trial, reporting at a trial, but you did not know about any of the other murders until after the verdict. Juror 15 says, right. Yeah, I had no idea of anything else she had been through prior to this trial. And even during the trial, I didn't know that. During this hour-long interview, Juror 15 repeatedly stated that he did not know about the defendant's prior murders or sentences before the verdict in this case. Juror 15 spoke with multiple media outlets who accosted him as he was attempting to get to the juror bus. The videos provided by the state in Exhibit A, listed as Idaho News on Demand, is the first contact by the media with Juror 15, where he clearly states twice that he did not know that the defendant had been convicted of 3 other murders prior to the verdict. The defendant is later interviewed for an hour on the Hidden True Crime podcast, where he advised that as soon as he was released from the admonition and while he was still inside the jury room, he was Googling the defendant. Juror 15 advised Matias that this is when he learned she had prior convictions. So I don't want to beat a dead horse. It goes back over this again. I'd kind of like to get to the other part of the motion, unless you have anything else you want to comment on, Joe.
No, we can move on. We can definitely move on.
Yes. Yeah, and people in the chat are mentioning mistrial. This is a motion for a brand new trial, not a mistrial, which would be a nightmare for the victims and the family. I just really, really hope that we don't have to go through that. I hope nobody has to go through that.
Honestly, if that does happen, I put part of the responsibility for that on the court for not conducting juror protection like they should have. I absolutely would. I would put the majority of that. I'm not saying 100%, but I would put a good part of that blame on the court for not handling the jurors properly.
Yeah. I don't think this is likely to go anywhere. But that's my hope is that it won't. So then addressing the Tylee Ryan and Alex Cox statements, which honestly, she's right about this. It says they were appropriate precluded as hearsay statements, and the detective Daniel Kuhn's expert testimony was based upon the physical evidence. She talks about them appropriately filing motions. There's no exception that permits their admission, the exception that admits hearsay statements. The court precluded the statements by Tylee Ryan made almost 3 hours after the shooting as hearsay. The court ultimately precluded any statements by Alex Cox to the police from both when the police first arrived 47 minutes after the shooting, as well as the statements he made at the police station a couple hours after the murder. The state also objected to, and the court sustained as hearsay, any testimony regarding Alex Cox's walkthrough with police nearly 8 hours after the shooting. Detective Daniel Coons was noticed by the state as an expert witness to discuss the trajectory of the shots at the crime scene. During his testimony, the state asked Detective Coons if, based upon his training experience, the location of the casings, projectiles, bullet strikes, and injuries to Charles Vallow, if he could determine an approximate location of where the shooter would have been standing when the two shots were fired. Detective Coons then provided his opinion that the shooter would have been standing in the area between the curved wall, kitchen, and the hallway. And for those of you who have not seen, I actually showed a slide in when we were waiting for the trial that shows exactly where everything was located in the house. And I'm going to attempt to share it with you right now so that we can take a look at it. There is actually a lot in that waiting for the verdict video that I would like to parse up, because I went through the FOIA docs and read a lot of the text messages that were not read into the court record. So I want to go back and clip those out for you guys so that you can see and hear them. And I think I have to take this one out and then image file maybe. There we go. See if I can share that. So I put these words on the layout drawing that was presented as evidence in the trial. And so you can see where Charles's body is laying. Just at his feet is a curved wall with an entrance into the kitchen. And directly below that is the hallway that Alex would have come from after retrieving his gun. And so that's what Detective Coons is talking about, that he believed that the shooter was standing near the curved wall just outside the hallway there. So I hope that that helps people. I'm a visual person, so that I hope that that helps you to see what we're talking about there.
It absolutely does, yes.
Okay. So back to this here. So standing between in the area between the curved wall, the kitchen, and the hallway. The defendant never established a foundation that any statements made by Alex Cox or Tylee Ryan hours after the shooting were admissible under any of the Arizona rules of evidence. The testimony of Alex Cox and Tylee Ryan were appropriately precluded. Detective Coons gave his opinion. This is kind of a restatement of what we already talked about. Detective Coons did not ever indicate that his opinion was based on the statements or walkthrough of the defendant's co-conspirator. And I think that's the crux of the argument there. And then on the discovery violation, on January 13th, the state filed the state's notice of disclosure and request for disclosure, advising the defendant the state would use any evidence arising out of Chandler Police Department report, names the report, any information relevant to the case obtained from Cellbrite downloads, and that all requests to examine or scientifically test items of evidence must be in writing. Lori did not put that in writing until March 12th, 2025, where she noticed Lonnie Dworkin as an expert. Defendant never provided the state any notice regarding Dworkin's testimony. On March 13th, the state was advised that Dworkin had not begun work. On March 16th, the state filed state's motion to preclude the defense expert. The state filed a separate statement in support of Rule 15.7 sanctions due to the late and incomplete notice of the defense expert, Lonnie Dworkin.
Okay, I have a problem with this. I have a problem with this just from a defendant's rights standpoint.
Yeah.
You shouldn't have to provide the state a notice that you want to see the evidence that they're going to produce in trial. They should provide that to you in discovery every time, all of it. Just give it all to the defendant. Like, why should the defendant tell you that they want something that you're going to use for evidence in trial? That doesn't seem right to me. The fact that she didn't.
Is she just clarifying that Lori didn't notice that she had an expert witness? Or is she?
No,
Okay.
go back to the top, go back to the end of the top paragraph. All requests to examine or scientifically test items of evidence must be in writing. No, I shouldn't have to tell you in writing that I need to see your evidence. You should give me all of your evidence and discovery. Absolutely. And
Yeah.
they should have. This
Yeah.
could be avoided if they just give her everything. Give her the, what was it, the gray box? I think the gray
cell.
key.
Gray key.
Great.
Yeah.
Gray key. Yeah. Just give her the gray key evidence. She doesn't know what to do with it. And she doesn't have an expert to do anything with it. Just give it to her.
Yeah. And
so
I don't know if she was intentionally being cagey with that, or trying to hope to trip Lori up in some way. If she was, that's probably not the best professional conduct. I know that Lori
I don't think she had professional misconduct. I just don't think that I agree with that assertion that you need to tell me in writing if you want to examine something.
Yeah. And maybe they'll clear this up in the hearing as well. I wonder if it's a specific Arizona rule that has to be in writing, or if it's just something Trina put in her motion, or her response, where she wanted Lori to request things in writing. So hopefully they'll clear all of that up. But thank you for adding that, because I agree with you. If it's just an arbitrary statement and not a rule of evidence, then that's probably not the best thing. Let's see. On March 18th, the defendant was asked by the court about Lonnie Dworkin. The defendant was advised that she could request a continuance to allow time for her expert to review the victim's cell phone. The court further advised the defendant that anything an expert discovered could potentially be precluded. The defendant advised she wanted to proceed with the trial instead of seeking a continuance to allow her expert time to review the victim's cell phone. The defendant advised that she would like her expert to review Charles Vallow's actual cell phone. This was the first time the defendant requested access to this item of evidence. On March 18th, the state emailed a stipulation to the defendant's investigator regarding the release of Charles Vallow's cell phone to defense expert Lonnie Dworkin to allow the expert to extract the cell phone. Jury selection for the trial began on March 31st. The cell phone was returned to the Chandler Police Department on April 3rd. On April 7th, while the state and defendant were presenting evidence and testimony in trial, the defendant emailed a motion to dismiss for failure to disclose exculpatory evidence and prosecutorial misconduct. The motion provided no facts to support that any exculpatory evidence existed, nor did it provide any facts to support prosecutorial misconduct, although it did call out my boyfriend. Attached to the motion was an affidavit from defense expert Lonnie Dworkin requesting the raw data from the gray key extraction of, among other items, Charles Vallow's cell phone. The defendant's expert did not advise that exculpatory evidence existed. It only provided that newer versions of Cellbrite might be able to locate additional data that was unable to be located in the 2019 and 2020 versions of Cellbrite. On April 10th, the state provided the defendant with a thumb drive containing the gray key raw data for Charles Vallow's cell phone, iPad, and MacBook to give to their defense expert. The state has not received any reports, notes, affidavits, or information relating to Lonnie Dworkin's review of his extraction of Charles Vallow's cell phone or his analysis of the gray key raw data. I'm hearing some feedback in my headphone. Can you hear me okay, Joe?
I hear you. Can you hear me okay?
Yeah, I hear you fine. I just wanted to make sure that it wasn't me.
It's Lori reaching out to you from her cell.
It's a portal. There's a portal opening.
Beware the portal.
Let's see. The state has not received any information advising that any exculpatory evidence was withheld from the defendant. Instead, defendant's motion for a new trial makes a conclusion without any support that the gray key raw data contained exculpatory evidence. I happen to agree with this. She's just making the conjecture, and then she's also making the conjecture that the state won't be able to prove beyond a reasonable doubt that that she deserves a retrial. Then she cites some Brady law. The evidence is material only if there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceedings would have been different. In this case, the defendant did not provide the state in writing a request to examine the gray key raw data until April 7th.
She shouldn't have to. Nope. She
I
shouldn't have
get
to.
you. Furthermore, the defendant has not provided any documentation to support the claim that the gray key raw data included any exculpatory information that was not part of the Cellbrite data that was disclosed to the defendant on January 9th. Well, I have a problem with this because how would she know if it has exculpatory evidence until she's had a chance to examine it?
Exactly. Yeah.
And then she says doesn't support a Brady violation. And then addressing prosecutorial misconduct. On April 8th, the state elicited from retired Captain Kent Keller a statement made by the defendant while she was standing across the street from her rental house approximately an hour after her brother shot and killed her husband. The statement made by the defendant was admissible under 801D2 as a statement by party opponent. Furthermore, the statement was relevant to show the defendant's demeanor, which we talked a lot about. It was very nonchalant during the investigation into the shooting of her husband. On April 21st, court read the final jury instructions to the jury. The jury was advised. In their opening statements, the prosecutor and defendant talked to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and we'll talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. During closing arguments on April 21st, the state made an argument to the jury about all three of the justification defenses: self-defense, defense of a third party, and crime prevention. The defendant has intentionally mischaracterized one sentence from the state's closing to claim prosecutorial misconduct. The state provided both facts and evidence to support why the defendant was not entitled to self-defense, defense of a third party, and crime prevention. During closing arguments, the state made an argument to the jury based on Exhibit 210, 227, and 222 that on July 9th, Alex Cox made plans to have his brother Adam Cox stay with him the night of July 10th. Alex Cox's plans changed later that night of July 9th when the defendant requested her co-conspirator Alex stay close to her the next couple of days. The state's exhibits showed that Alex did not answer his brother Adam Cox's calls or texts. Although the state did interview the defendant's sister, she told the state and Detective Duncan that she spoke with Alex Cox. We're talking about Summer now. Summer spoke with Alex Cox the night of July 10th and begged him to stay with the defendant. Again, one text message, but we don't know what else there might have been. The state therefore was able to infer that since Alex Cox did not respond to Adam Cox hours before the defendant's sister spoke with him, that his plans to stay with the defendant were based upon his discussion with the defendant on July 9th. During closing argument, the state made argument to the jury regarding the defendant's demeanor from the time she arrived at the scene almost an hour after the shooting through the time that she handed over the cell phone to Detective Inclan around 3 p.m. on the day of the shooting. Witnesses described the defendant on July 11th as chatty, nonchalant, and unaffected.
Not nonchalant. Not again.
Well, they did say it, so she's really just saying,
so many
she's really
times,
restating. Yeah.
It's a good thing people didn't have a drinking game based on nonchalant.
Seriously. Yeah, we all would have been wasted. And unaffected by her brother allegedly being struck with a baseball bat, her husband lying dead in her house, and her children no longer having a father. The defendant's demeanor with law enforcement the day of the murder was in complete opposition to the defendant's demeanor during opening statements, where the defendant attempted to testify as to facts that were never brought in by the defendant during the trial and crying in front of the jury. Do you remember that,
Oh,
Joe?
yeah.
How did you feel when that was going down?
I was like, give me a break. So I remember discussing it afterwards. And it felt to me an awful lot like a fast and testimony meeting. Do you know when, especially women,
do you mean open mic Sunday?
Yes, right. And when they get up, and at some point in time, the women who get up will cry at some point in time. And it felt an awful lot like that. Like it was internally motivated. And I'm not bashing fast and testimony meetings. I'm not at all. Like I've said many times, I have lots of friends and family that are LDS and they believe what they believe and they feel strongly in a lot of cases. And obviously she feels very strongly too that she's not guilty. And I don't feel the same way.
Yeah, I am guilty as charged. I was one of those women who would get up and cry in testimony meeting, not on purpose though. I definitely would cry because I felt very strongly about what I was saying, and
Right.
I believed what I was saying at the time, and so
I think she believes what she was saying too.
I think she believes what she was saying, but I don't think that she was sad. She
No.
did
Oh,
not
no,
come
no,
off
no.
to me as
Yeah.
sad.
No.
What it came off to me as her affecting emotion and then making a really big deal about wiping her eyes and asking for a Kleenex, interrupting her statements to ask for a Kleenex. So that's what I remember. I just remember thinking, all right, here we go. She's wiping her eyes, and then she had to stop her statement to ask for a Kleenex.
Well, you use the phrase affecting emotion, and that's, I think, where I was trying to get with the fast and testimony meetings and the people that cry at those. I think affecting emotion might be a way to describe some of what goes on. Not all of it. I'm not throwing a blanket on it, but affecting emotion. And that's what the LDS Church does too a lot of times. Like when they have like an open house and they invite non-members in and they have their solicitation videos that they put up, they're trying to affect emotion.
Right. They do use that elevated emotional language and, videos with heartwarming music, etc.
My sister literally asked, so I left the church and I married a non-member when I was 19, 20. And we went to one of those meetings. And at the end of it, my sister says, "Do you not feel a stirring in your emotions?" And of course, my wife, my young wife, and I was young too, said, "Yeah, I did feel some." And my sister said, "Well, don't you think that might be the Spirit moving you to join the church?" And my wife was like, "No." She's like, "No, that's my emotions. That's not the Spirit moving me to do anything." And I thank God that she did.
Yeah. Oh man. So I have a lot of feelings about all of that, and it's probably a rabbit hole I don't want to go down at the moment. I will just say that there is a trait in psychopaths. I'm not diagnosing anyone or saying anything that Lori is a psychopath or is not a psychopath, because I'm not a clinician, so I'm not qualified to do that. But there is a trait about psychopaths that they know how to mirror real emotions. They know when they're supposed to cry. And so they will try to make themselves cry at a moment when they're supposed to cry. I will also say that when I was singing opera professionally, I could make myself cry on stage if I needed to. So, it can be manufactured. It didn't seem genuine to me, but that's my
No,
opinion.
it didn't feel genuine either to me. But cry on demand manufacturing, I couldn't do that when I was younger. But ever since I lost my Charlie, I can do it now. Like it's making me sad right now. Like, so that's, I imagine that's how some actors can do it. Like remembering something that's really sad in your life.
Yeah, you just they tell you to access an emotional memory that mirrors what your character might be going through. And, that empathy piece helps a lot with it as well. I cry when I see other people cry sometimes. But again, also, I cry when I watch the Olympics. I cry when I watched the Shamu show at SeaWorld when I was younger. I get emotional about a lot of different things because when I witness something that's beautiful or poignant, I just cry. That's just how it is. So yeah, by the way, hi Kresha, I'm so glad you're here. I think Lori was crying for herself. I think that's a good theory. Yeah. And she could have been crying because she knew that she was she was effed. That's very plausible. Okay, so let us move on. We're only, I think, on page 13, and we've got a long ways to go here. So where were we? Let's see.
I have no idea. I'm totally lost.
Okay. In determining whether an argument is misconduct, we consider two factors. One, whether the prosecutor's statements called to the jury's attention matters it should not have considered in reaching its decision. And two, the probability that the jurors were in fact influenced by the remarks. In this case, the state did not argue or raise any matters that the jury should not have considered. Each of the inferences and arguments made by the state during its closing argument were based upon the testimony of witnesses and evidence admitted at trial. Then the court's impartiality. State filed 3 separate motions to preclude the defendant's noticed witnesses. After each motion filed by the state, the court heard argument as to the late notice, lack of the witness being made available to the state, and their relevance to the trial. The court did not preclude most of the witnesses, even after multiple requests by the state. This kind of seems like Trina is like, I asked for them to be precluded, and the court didn't even preclude them. One witness the defense noticed, Nate Eaton, is a reporter with no personal knowledge of the case. Mr. Eaton filed his own motion to be allowed to remain in the courtroom. Later, Mr. Eaton's attorney filed a motion with the court. The court heard argument by Mr. Eaton's lawyer and the defendant. Mr. Eaton's lawyer argued to remove Mr. Eaton from the defendant's list of witnesses and allow him to remain in the courtroom during the trial. During this argument, the court asked the defendant why she needed Mr. Eaton, a reporter, for trial. The defendant indicated that Mr. Eaton might be used to impeach a witness who testified. The court advised the defendant that she could impeach a witness with Mr. Eaton's recordings. The court also advised the defendant that if she felt Mr. Eaton became a necessary witness, he would reconsider his preclusion even if Mr. Eaton was in the courtroom during their testimony. The defendant never requested to call Mr. Eaton to impeach any witness. And here's an interesting thought that I just had. I wonder if Lori even had any exhibits that she was going to present as evidence.
Well, she only had an hour a day when she wasn't locked up and locked down, so I don't know.
And also, it's really hard to get the phone calls, the communication, so they might have misunderstood. And Lori could have asked for something to be brought in as an exhibit. And, she could have asked for keys and they brought in cheese. And she would say, no, not the cheese, the keys. Anyway. I'm a little punchy over this. All right. The state filed 2 motions seeking to remove Brandon Boudreau from the defendant's witness list as he's a listed victim. During the trial, the parties interviewed Brandon Boudreau. In this interview, Mr. Boudreau advised he was not aware that Adam Cox was in town or that Charles and Adam were planning an intervention. The defendant was unable to provide any other basis for calling him as a witness. The court struck Brandon Boudreau from the defendant's witness list without prejudice, again advising the defendant that should Mr. Boudreau become relevant, the court would be open to hearing her argument. The defendant did not request that Brandon Boudreau testify. On April 10th, the defendant cross-examined Serena Sharp. The defendant asked the witness if several named people in the Bible were translated. The state objected to this as relevant. The court allowed the defendant to continue questioning the witness about this area. The defendant never asked Serena Sharp or any of the 3 other witnesses who were members of the Church of Jesus Christ of Latter-day Saints who testified during this trial if they thought that it was a, quote, regular part of the Mormon religion for a current living person to be a translated being. That was my argument too. Instead, the defendant merely asked one witness if there were people in the Bible who had been translated. As far as we know, Lori was not in the Bible. That's just my addition.
I need to Google that. To clarify.
Okay, please let me know what you find out. I would love to be proved wrong. It is well established, however, that a trial judge is presumed to be free of bias and prejudice. To rebut this presumption in a criminal case, a party must prove by a preponderance of the evidence that the judge is biased or prejudiced and must file a motion alleging specific grounds of impartiality. Here, the defendant has admitted that the court overruled the state's objection, but argues that one comment by the judge during a 2-week trial somehow rises to the level of establishing a preponderance of the evidence that the judge was biased or prejudiced. The defendant has not shown.
You know what?
Yeah.
You know what? It could be. There could be one statement by a judge, if it really is out of line, that could screw up a trial. I'm not saying this was. Judge Bresky is awesome, and he drives a cool convertible, but I didn't see that it rises to that level in this case. But I'm just saying, in general, a judge might screw up a case if he's out of line. I don't think Bresky was anywhere near out of line in this case.
Yeah. That's funny that Kay, when she got sworn in, she said amen instead of yes.
That's awesome.
I love it. I appreciated his comment as well. And I think it's super cool that he has an awesome convertible. It kind of makes me want to have him on the show. Judge Bresky, if you're watching, I'd love to have you as a guest on the Midlife Revolution podcast. I would love to hear about your convertible because I'm a car person.
After Brandon's trial, or after Lori's trial. Yeah.
Yeah, after the everything. Yes, please. Let's just, goodness. So the conclusion is the defendant's motion for a new trial should be denied since the evidence supports that Juror 15 did not know about the defendant's prior felony convictions before reaching a verdict. The court properly excluded the hearsay testimony of Alex Cox and Tylee Ryan. The state's expert witness, Daniel Coons, relied upon the physical evidence at the scene and the autopsy of Charles Vallow to reach his conclusion as to the trajectory and general location of the shooter. There has been no discovery violation by the state. There has been no prosecutorial misconduct by the state, and there is no evidence that the court was biased or prejudiced against the defendant. So there you go. Closing thoughts, Joe, on any of this or all of it?
I think Trina did a good job responding. She covered everything in detail like she did in closing.
Yeah.
Right?
Yeah, I think she did a good job. And I think we're probably going to hear some more questioning and testimony about this on the 14th. But I will count on you to let us know if anything gets filed before then.
I will be here and I will be there.
Yeah, good. I'm excited. I'm excited to hear. I'm definitely going to be covering the hearing. I will do it the same way that I've done before, where I will go live just a little while before the hearing comes on, recap what we're doing, and then when the hearing actually gets played, I will play it on my channel as well, and then we'll have a little bit of commentary afterwards. So as I said, I am going to continue covering the case despite some people not wanting me to. I will be here. I feel like I have important things to add to the conversation. And even if I were not an admittedly estranged family member, I still believe that I have an important perspective because I've dealt with so many people in my life like Lori, and there were so many people who are, and I believe unfortunately still are, snowed by her. And I think Juror 15 was one of those. He said he felt sorry for her. He said he felt like when she gave her opening statement that she was very compelling. Did you notice that, Joe, in the interview with that Carl did?
Yes, I noticed that, but also in court, one of the last days in court, there's another instance that I didn't tell you about.
Okay.
So by the time we got to the end of the trial, I was getting my groove on, like I was figuring out what I was there for. So I'm taking handwritten notes in my notebook. I'm also trying to listen to the testimony of the witnesses, but I'm also trying to observe the reactions of the jurors because the people that are watching on court TV and the other media outlets can't see the jurors' reactions to what's going on in court. And one of the last days, I got seated on the left side behind Lori's side, behind the defense side. So, but that means that I had a better view of the jurors. And there was one point in time when juror number 15 was looking up from his notebook, and he's looking around. He's just kind of like glancing around the courtroom. I'm like, okay, he's a little bit bored. He's a little bit whatever. But he stops and he stares at Lori for a good 10 to 15 seconds, like dead on staring at Lori for like 10 to 15 seconds. And that caught my attention enough that I wrote it down on my notebook. I'm like, Juror 15, what are you doing, buddy? Like, what's going on in Juror 15's head? I don't know. He's had interviews now, so we know a little bit about what might have been going on in his head, but like, he literally stared at her for a good 10 to 15 seconds, just out of nowhere.
Yeah. Yeah. Interesting. And I will say as well that that I noticed Victoria, I noticed her staring at Kay on the last day. So it's hard for me to say. I think as a juror, I probably would want to know how the family was reacting to things. And I would definitely be watching Lori's reactions.
Yes.
And there was more than one juror who said that there were periods of time where Lori would roll her eyes. She would try to make eye contact with them. She would react to things, trying to see how they were reacting to things. So she was definitely trying to play the jury.
Didn't work.
Yeah.
It didn't work.
Yeah. And Intervisions, we're not saying that we know Carl or that we know anything about him other than what was portrayed in court. Commenting on just the several difficult moments that he had with the judge where, there were several times when he was called out for different things. And so, I would love to be wrong about the fact that, I think that he had some problematic things going on. I'm just observing what I saw of his behavior personally, what I personally witnessed of his behavior. I think Joe's doing the same thing. I'm not faulting him, and I'm certainly not trying to second guess because I have no idea what it would be like to be called to be in a jury for such a, number one, high profile, but also horrific case, and to have that stick with you for the rest of your life. I've gotten to know Tom Evans, who was a juror on the first Lori trial, and his entire life was changed by what happened in that courtroom, what he was forced to witness, and his jury service. So I have a lot of compassion for jurors and for their service. In fact, I'll even say that when I got a jury summons this last year, it really changed how I feel about jury service. It was something I previously, thought, oh, let me see if I can get out of this. Now I realize how important it is to have a fair and impartial and intelligent jury. And so I was actually looking forward to serving. Unfortunately, I wasn't chosen. But I definitely look at it differently now, and I have a lot of compassion for jurors.
Yes, it's a tough job. And in this kind of a case, it's an incredibly tough job. And under this kind of media scrutiny, it's an incredibly, like, to the factor of 10 or 100 more difficult job. But I'm also not doing my job if I don't point out problems, and I'm not, without making judgment, I'm just pointing out facts about things that we witnessed in the court. The judge calling him back 3 times, me observing him standing near the public once, and then the statements that he made to Fox 10 afterwards. Those are facts. I'm not making a judgment about him. And he was given a chance to clarify on Hidden True Crime with Lauren. And that's awesome. And I'm glad he did, because now I can take him at his word. But if I'm looking at it from a legal aspect, the judge can't take him at his word. The judge needs to call him in and say, clarify for me what you meant by these statements. So, and those are in the court filings. Those are in Lori's motion, and those are in the state's response to her motion. Those are actually in court filings now. Like Lauren from Hidden True Crime is in a court filing now.
Right.
That's probably not the first, that's probably not the first time, but she's in there. Her interview's in there. They can replay the video. Yeah. So I don't think just by calling out those things, I don't think we're making a judgment of Juror 15.
No,
we just all need clarification, and we all need this thing to go away. I think Kay said it best afterwards. Just, what are you doing, buddy? Just go away. Let this whole thing just go away.
Yeah. And just by saying that something is a problem, that's not a judgment statement. It is a problem when the judge has to call you out specifically for your behavior in the courtroom. So all we're saying is that, problematic things, and we hope it doesn't result in anything that's going to give Lori any more. So someone was asking, a mistrial, a new trial equal or the same? They're not the same. A mistrial is where the entire case gets dismissed because of something that happens during the court case. A new trial is just where they retry the entire case from the beginning. Lori would be able to call witnesses, new testimony, all that. Everybody would have to testify again. Like we're talking Arizona, Charles Vallow case 2.0, basically. And that's what Karen Reed is getting right now, a new trial. So I don't know enough about that case to comment on it, so I'm not going to, but it's definitely...
That was actually a mistrial.
A big case. Oh, was it a mistrial?
It was. The jury was hung.
Okay.
So Judge
Gotcha.
Beverly Canoni declared a mistrial. So
Yeah.
The jury wasn't hung in this trial. They declared her guilty. So that's not going to be the same thing.
Yeah. So a hung jury just means that there was not a unanimous guilty verdict. And so that means a mistrial and they start over.
Yes. She sent them back several times to go deliberate again, go deliberate again, go deliberate again. And after several times of that, they said, we just can't reach a unanimous verdict. So she said, okay, mistrial.
Yeah. Wow. It's a lot. Well, I am ready to take a break.
Yes.
So
me too.
I really appreciate you being here. You're always so generous with your time. And thank you so much for sharing all of the actual motions, because it's a lot easier to read them here than to figure them out on Twitter, or X or whatever. So I really appreciate it.
Well, thanks for having me on, and I promise I'll get my lighting figured out someday.
Well, you know what? When you're traveling, it's not the most important thing. And I just found when I was there for the trial, I just had to go with what I had. And what's really funny is I think one of the first nights after court, I came back to Tom and Susan's place, and I had an interview on Court TV, and I just found a corner and went over there. And when they called me, they were like, can you do anything about your lighting? And Susan literally brought a lamp over from the living room and put it on the bed next to my laptop. And I was sitting on the floor. My laptop was on the bed.
Oh my
So
gosh.
that's just all I could make happen in that moment. And then the rest of the lives that I did from Tom and Susan's place, I did in the bathroom, because it was the only place where I could close the door and not interrupt what they were doing.
Well, maybe I'll try that next time.
Yeah, it was pretty funny. It was a little echoey in there.
I bet. Yes.
Yeah.
Well, thank you for having me on.
I appreciate you. Yes. And as always, everybody, please go subscribe to Joe Schmo 88 here on YouTube. He's got a great channel. You do morning coffee true crime recaps. Is that right?
Not every day, but on a regular basis. Yes.
Nice. Awesome. Yeah. So I probably will see you guys again. The next time I will see you. Well, I'm going to release a video tomorrow. I've already recorded it. Needs to be edited. But that video is a Nancy Jo Hancock appreciation video. I break down how Nancy Jo shuts down Lori with her gray rock tactics. And then after that, we'll see what comes next. Probably on Mother's Day, not going to release a video, but I may go live later in the afternoon on Saturday. I know Mother's Day is a really hard day for a lot of people, and I want to provide a safe space for anyone who needs one just prior to Mother's Day, and just give some tips about how I sort of changed my perspective on Mother's Day and how I made it a day that I loved instead of a day that I dreaded. So I'll have that probably Saturday afternoon. So that's what I've got coming up. Anything for you, Joe?
No, Mother's Day is tough for me because I lost my mother in 99 and her funeral was actually on Mother's Day on my birthday in 99.
Oh my gosh. So, wow.
So I'll probably be joining you for a safe place to come and hang out. How's that sound?
Yeah, definitely. I want to give people some ideas about how to make that day less painful if it is painful for you. So
Yep.
to all of you who do celebrate Mother's Day in happy ways, happy Mother's Day to you. And I will hopefully see some of you at least tomorrow afternoon. So have a great night. Take care of yourselves. Take care of each other. And I'll see you soon.